May I please allow you? My lord, I am praying for listing of a bail application, my lord. Earlier it was listed, my lord, but left over, my lord. So on Wednesday or Tuesday, my lord, 23 or 24, my lord. LCR also come, my lord.
Okay, on Wednesday.
Obliged, my lord.
Wednesday means 23rd.
23rd.
I think it was 16 or 17.
Okay.
May I please? I have reference for listening of 25th. He is in custody, lordship. Yesterday, this matter was listed and probably your lordship fixed it on 25, but when I checked it online, that date not given was shown. Therefore, I am making mention of
25th.
20. Obliged. And another pair, lordship, item number 3 may be taken up as last motion, lordship.
Okay.
Obliged.
Make cases a lordship. Lordship, I have a careful listing of a bail application on Thursday, my lord. It was listed yesterday, but matter could not reach, my lord. Thursday, I'm playing, my lord. He's already in custody, my lord. It will be on 54 days, my lord.
24th.
24th, my lord, Thursday.
One IoT has to correctly of the order. So it will come on Monday, my lord.
When? Monday we have many cases. Tuesday. 22.
May I please, your lordship? Your lordship, I beg to mention a bail application concerning POXO. On next week, any date, Friday also will.
When have you filed?
We have filed on 3rd of June, your lordship. Motion is, order is stayed, your lordship.
Okay, 24th.
Much obliged.
Please, your lordship, I get some mention for listing. The number 1583
24th.
24.
May I please, your lordship? Lordship, I get to mention for listing on AB lordship.
24th.
23rd.
24th.
May I please, your lordship? Lordship for listing 1BA. Anything.
When have you filed?
It's already 8/5/2025.
24th.
For withdrawal item 23 and 24 from supplementary list.
Why are you withdrawing?
Lordship, party, you know, the interstate lordship.
Heard, Mr. What is your name?
M. Rahman.
M. Rahman, learned counsel for the petitioner, who prays for allowing the petitioner to withdraw the instant bail application. Prayer is allowed. This case is dismissed on withdrawal.
Yes.
Same in item number 24.
25.
We have withdrawn money.
Heard, Mr.
No problem.
S. Bora, learned counsel for the petitioner. Same order. Dismissed on withdrawal.
Obliged.
Lady, this motion be item 1.
May I please, your lordship? My lord, regular bail application, my lord. I was arrested on 1/7/25, 19 days in custody, my lord. FIR page 9, my lord.
Where is the rejection order?
My lord, rejection order page 19, my lord.
It's pending investigation.
My lord, actually, my lord, Imran Ahmed is the owner of the, my lord, hotel, my lord. I am the employee, my lord. And my lord, I have 19 days in custody, my lord. Already, my lord, I have been thoroughly interrogated. I have been thoroughly interrogated, my lord. And my wife also, my lord, 11th week pregnant, my lord. No other person are there, my lord, to look after her, my lord. I am the, my lord, kindly turn to page 10, my lord.
What is the affair?
My lord, page 9, my lord. Page 9. Page 9. Mughal Garden, the name of hotel, my lord, and I am the employee, my lord, and one Imran Ahmed. It is reflected in the affair itself, my lord, page 10.
Imran Ahmed
Is the owner of the hotel, my lord, page 10, my lord. So I am the, my lord, I am Farid Ali, my lord, I am the employee.
Imran Ahmed has been,
Arrested, my lord, has been arrested.
whether has been granted bail.
He, my lord, I have no idea, but he has been arrested. He is the owner, my lord. I am, my lord, just employee, my lord.
Yes, Mr.
19 days in
Goswami.
custody, my lord.
Imran Ahmed has been released on bail yesterday.
How many days I am the, my lord? On provisional. My lord, he's the main accused, my lord. I am his employee, my lord.
But your lordship will find, my lord, around 20 kg of.
It has been seized, already
not found,
seized.
my lord. So they have much more than, my lord.
He already seized, my lord. Further
Yes, it is
custodial.
seized.
Okay, heard
But-
Mr. S.H. Sigdar, learned counsel for the petitioner. Also heard Mr. M.P. Goswami, learned additional public prosecutor. This application under section 483 of BNSS, 2023 has been filed by the petitioner, namely Faridul Ali, who has been detained behind the bars since 1/7/2025 for last 18 days in connection with Bahata Sareli PS case number 167/2025 under section 299/196 of BNS, read with section 13 within bracket 1 of the Assam Cattle Preservation Act 2021. The gist of accusation in this case is that on 1/7/2025, one Sumit Mahato, SI of police had lodged an FIR before the officer in charge of Bayata Chareli police station, inter alia, alleging that on receipt of an information that some hotels are selling illegal beef meats, a search was conducted in the hotel named within inverted comma Mughal Garden Shahi Darbar located and Bismillah Hotel located at Nagaon PWD Road. During such operation, 20 kg of beef meat was recovered from the said hotel. Learned counsel for the petitioner submits that the petitioner is only an employee of the said hotel and the owner of the said hotel is one Imran Ahmad, who has also been arrested in connection with this case. Learned counsel for the petitioner submits that the petitioner has been detained behind the bars for last 17 days, and considering the period of detention, he may be allowed to go on bail. On the other hand, learned additional public prosecutor has prayed for calling of the case diary. Stop.
Also, my lordship, kindly peruse paragraph 4, my lord, of the petition, my lord. He is a habitual offender dealing in such type of offense.
Habitual, I am the employee, first time
Paragraph
arrested,
4,
my lord. I have never been arrested earlier, my lord.
Petitioner begs to state that on where the petitioner working as was also served.
Earlier, my lord, police did not arrest, my lord. Please ask, my lord.
Learned counsel for the petitioner has submitted, learned additional public prosecutor has also submitted that in the said hotel on earlier occasion also, police found illegal selling of beef meat
32 kg.
of about 32 kgs. Stop. I have considered the submissions made by learned counsel for both the sides and have gone through the materials available on record. Considering the nature of offense involved, as well as the fact that the suspected beef meat has already been seized, as well as considering the fact of considering the period of detention, length of detention, this court is of considered opinion that Further custodial interrogation of the petitioner may not be necessary if he cooperates in the investigation, for fair completion of the investigation of Vijayata Sarali PS case number 167/2025. Stop. In view of above, the above named petitioner is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned SDJM Range with following conditions, condition 1 and 2. This bail application is accordingly disposed of.
Hello, Ablash. Hello.
Item two,
May please, your lordships. In this case, my lord, the petitioners were the, my lord, employees of the two hotels, my lord.
Same,
My lord, 17, my lord. Police station 17.
same hotel or separate
No,
hotel?
my lord, separate
It
hotel.
is
In the
separate
district
case,
of
my lord.
Borpeta.
This is from Borpeta, my lord.
Borpeta.
Earlier was from Bayatam.
17 days is sufficient time to complete investigation in such cases. Yes, Mr.
I
Gupta.
pay for the seeking, man. Because to ascertain whether they are habitual, my lord. Because
Yes, my lord. I have next all the documents, my lord, regarding, actually, they are, my lord, the part-time employees, my lord. They are actually students of, my lord, I have annexed the documents, my lord. That is, annexer 5. Annexer 4 is the certificate issued by the principal, my lord.
Heard Mr. S. Ahmed, learned counsel for the petitioner. Also heard Mr. MP Goswami, learned additional public prosecutor. This application under section 483 of BNSS 2023 has been filed by the petitioners, namely Iqbal Hussain and Rehan Ali, who are detained behind the bars since 1/7/2025 and 2/7/2025. No, 1/7/2025 in connection with Borpeta Road PS case number 65/2025 under section 13 within bracket 1 of Assam Cattle Preservation Act 2021. The gist of accusation in this case is that on 1/7/2025, one Sushmita Kaur, SI of police had lodged an FIR before the officer in charge of Borpeta police station, inter alia, alleging that on receipt of an information through reliable sources that in the hotels, namely Jannat Hotel and Dolphin Hotel of Borpeta Road, illegal selling of beef meat is carried on, a search was conducted in both the hotels, and during search operation, how much?
27 kg.
27.95 kg of suspected beef meat was recovered from the said hotel. Learned counsel for the petitioners has submitted that
there are two hotels, my lord. In one case, 27.95 kg and another, my lord, 27.8 kg.
yes, in one
In one is Jannat Hotel,
in
another is Hotel Dolphin.
in Jannat Hotel 27.95 kg and in Dolphin Hotel 27.800 kgs of suspected beef meat were recovered. Learned counsel for the petitioners have has submitted that both the petitioners are students and were part-time employee of the which hotel?
Dolphin Hotel and.
No. One my lord is the owner. Iqbal Hussain is the owner of my lord Dolphin Hotel. Petition number 1.
The
Oh.
owner is my lord, one Mohidul Islam, my lord, son of Samsul Haq, my lord.
As per the FIR, my lord. We apprehend the owner of the Dolphin Hotel, Iqbal Hussain. So one,
What is your submission?
My lord, my submission is that the owner is the, my lord, the one Mohidul Islam, my lord, son of Samsul Haq, my lord. I say they have already sent in PDF in my mobile just now, my lord. If, my lord, sometimes requirement.
Who,
I'm
who
employee, my lord.
you are employee
Yes,
and part-time employee.
part-time employee.
That is your
Student, my-
sub.
Yes, my lord. I'm a
ये
student.
लिखिए last line. Students and are part-time employee of the said hotels. He submits that considering the nature of offense, the period as well as the period of detention undergone, further custodial detention may not be necessary. He further submits that both the petitioners are ready to cooperate in the investigation. Hence, praise for allowing the petitioner to go on bail. On the other hand, London Additional Public Prosecutor has opposed the grant of bail at this stage and has prayed for calling of the case diary. Stop. I have considered the submissions made by learned counsel for both the sides. Since in this case, the suspected beef meat has already been recovered, and considering the nature of the offense involved in this case, the period of detention undergone by both the petitioners appears to be sufficient enough to for any custodial interrogation in cases of such nature. Hence, if the petitioners cooperate in the investigation, their further custodial detention may not be necessary. Stop. Accordingly, both the above named petitioners are allowed to go on bail of rupees 30,000 each with one surety of like amount, subject to the satisfaction of learned Chief Judicial Magistrate Borpeta with following conditions, number 1 and number 2. This bail application is accordingly disposed of.
Much obliged. So item 4, one thing, my lord, my lord, SI of Borpeta Road Police Station, my lord. Borpeta Road, my lord. My lord, Borpeta. It
The
should be Borpeta Road, my lord.
yes, case number is Borpeta Road.
Borpeta Road, my lord.
Okay, Borpeta Road.
SI of Borpeta Road.
Borpeta Road.
Yes. Much obliged, cautious. Obvious.
Item number. Yes.
It is daily application lordship. I am behind the bar lordship since last 495 days lordship.
Oh,
Item 4.
NDPS.
NDPS lordship. Lordship, I am looking for your lordship on your 2 grounds lordship that the arresting authority did not mention the grounds of arrest at the time of arrest in the arrest memo lordship as well.
What is the date of your arrest?
Date of arrest lordship 3/3/2024 lordship. 3/3/2024.
You have to find out, Mr. Goswami, whether grounds of arrest were.
Lordship, I have
Example,
annexed the,
LCRP call
No,
for me.
even if it is not mentioned in 50,
as well as the arrest memo also lordship. I have annexed the.
is
certificate.
there any other document on
No,
record?
lordship. No, lordship. I have annexed the certificate.
How much is the contraband?
Lordship, Caesar list at the.
What is the contraband?
21. Lordship,
Heroin.
How much?
400 something gram lordship.
We will go through the case, scan copy of the case diary. Heard Mr. T. Thakuria, learned counsel for the petitioner. Investigation is over.
Yes, lordship.
Yes, sir.
Charges have already been submitted. lordship.
Okay.
And lordship, charge has also been framed on lordship. 20.
Also heard Mr. MP Goswami, learned counsel for the petitioner. The petitioner has prayed for bail in this case on the ground that he was not furnished with the grounds of arrest at the time of his arrest in this case. Stop. Perusal of the scanned copy of the case diary would be necessary for consideration of the instant bail application. Hence, call for the scanned copy of the STFPS case number 4/2024 from the concerned trial court. Registry to issue requisition for the scanned copy. Let this case be listed on 7th of August.
Lordship, it has already been registered as NDPS case number 270/2024,
Okay.
pending before time.
No, but we need the scanned copy of the PS case number. 7th.
Obliged,
Item five.
obliged.
Right, Lordship. My lord, FIR case 9, Lordship. This case is also suspected to be issue, Lordship. I have annexed the invoices. Is 2021. This is not mid, Lordship. This is Buffalo.
So, act consult. What is the offense?
Ending of brief within 5 kilometer radius of the,
Of?
or five within, the
Oh.
situation temples.
Read the offense.
Plus,
Which is the provision?
FIR
once you kindly come to,
No, in the statute,
yes,
in the act.
first is matter, it is 6 matter without license slaughtering matter, section 6.
No, this is a case of finding beef meat.
Yes.
Yes, you submit. Where is the offense?
Under
Offense under section 13, Your Lordship.
under section 13, my lord, it covers everything, my lord.
But my lord, this is not beef, Your Lordship. This is the buffalo meat. I have annexed the invoices of the
No, I am not on facts. You have not understood my query. What is the offense in this case?
offense under section 13, Your Lordship.
Read it. Which provision you have contravened? Where is the provision that selling beef meat is prohibited? That I want to know. You are not ready with your case.
Just sometime I will take that.
Yes, Mr. Goswami.
Yes, my lord, may I kindly come to, section 13, my lord.
No, 13 is there. Contravention of.
Yes, my lord. And my
Where?
lord, as per the, my lord, section, my lord, section 13 is attributed, my lord. And section 13 says, my lord, if it is contravening provision 4, 5, 6, 7, and 8.
So which has been contravened?
4, my lord, 4, my lord, 6 is contravened because without license. Then again, my lord, section 4,
What is section 4?
prohibition of slaughter of cattle, my lord.
Okay.
Not restraining anything in slaughter or a kind being forced. No person shall slaughter or cause to be slaughtered or offense to be slaughtered for any cattle,
Okay.
provided that killing of a cattle shall not be considered slaughter. And 4, 5, without certification from the competent authority. Paragraph 5,
Section 4.
section 4, section 5.
No, where is the provision that
Yes, sir, that is also there.
you are also confused?
No, but it is there.
Tell me which is the provision.
Hey, next one, 5 years.
You come prepared. You have to be not after some time. Oh, okay, after some time. Beef meat is recovered
Yes.
in your hotel. How it constitute an offense? That is my question.
Section 8, madam. Prohibition on sale of beef and beef products. No person shall directly.
Yes, then.
Sell. Section 8, Lordship may kindly see, madam. Lordship has perhaps got it, my lord. Section 8.
Yes.
No person shall directly or indirectly sell or offer or expose for sale or buy beef or beef product in any form except at places permitted to do by the competent authority, provided that no such permission shall be granted in such areas or areas predominantly inhabited by Hindu, Jain, Sikh, and others, and non-beefing eating communities, or within a radius of 5 kilometers from any temple, satra, or other religious.
So the beef meat can be sold after seeking permission from the
Seeking permission
competent. And in this case,
there is
permission was not there.
not there, and license is also not there as per the section 13.
The accusation is only of selling of beef meat,
Yes, but-
not of slaughtering.
yes, ma'am. Because as per this section,
Since when you are behind the bars?
15 days.
Yes, Mr. Goswami.
Because well, he is running a, it is to be noted.
No, what is to be,
Approximate 2.7.
now, what is to be investigated, whether it is beef meat or not? Because
that is-
recovery is there,
The recovery is there.
Caesar witnesses are there.
Yes,
So what further remains for investigation? Only the FSL report.
yes. FSL report, that will one thing, minor. Other things, minor.
And then why do you need his further custodial detention beyond 18 days? 18 days is long period.
That will be my prerogative of the minor investigating authority, minor. But the statute provides 60 days, minor. So it cannot be as a matter of right, my lord, can be 15 days or 16 days,
Yes.
my lord,
Yes.
because
This court will have to
lordship. It's a discussion of your lordship.
heard Mr.
Yes, sir.
S. Hawk. When you appear before the court, you have to ready with all facts so that you can answer the queries. S. Hawk, learned counsel for S. S. Rahman, learned counsel for the petitioner. Learned also heard Mr. M.P. Goswami, learned additional public prosecutor. This application under section 483 of BNSS 2023 has been filed by the petitioner, namely Mominul Haq, who has been detained behind the bars since 1/7/2025 within bracket for last 17 days in connection with Gobardhan PS case number 68/2025 under section 13 of Assam Cattle Preservation Act 2021. The gist of accusation in this case is that on what is your name? Mominul. On 1/7/2025, one Shri Gopal Das, SI of police, had lodged an FIR before the officer in charge of Govardhana police station, inter alia, alleging that an information was received through reliable sources that two hotels, namely Bismillah Hotel and Mewati Muslim Hotel and Dhaba, situated at Helonar Palm, Similaguri, were selling beef meat without any authorization. And accordingly, a search operation was conducted and 10.81 kg beef meat was recovered from Bismillah Hotel and 2.730 kg of beef meat was recovered from Mewati Hotel and Dhaba. Learned counsel for the petitioner has submitted that. What is your submission? You are owner or employee of which hotel? Learned counsel for the petitioner has submitted that the petitioner is the owner of Mewati Muslim Hotel and Dhaba, and only 2.730 kg of beef meat, suspected beef meat, was recovered from the said hotel. he submits that the meat which was recovered is not of beef, but of buffalo. That is your submission.
Yes.
Stop. On the other hand, he also submits that considering the period of detention undergone by the petitioner may be allowed to go on bail. On the other hand, learned additional public prosecutor has opposed the grant of bail at this stage and has prayed for calling of the case diary. Stop. I have considered the submissions made by learned counsel for both the sides and have perused the materials available on record. From the materials available on record, it appears that the suspected beef meat has already been seized, and whether it is beef meat or buffalo meat would be revealed only after receipt of forensic laboratory report. However, considering the nature of this case and the fact that the petitioner has been detained behind the bars for last 17 days, this court is of opinion that the period of detention undergone by the petitioner is sufficient for subjecting him to custodial interrogation in any offense of such nature. Stop. His further custodial interrogation does not appear to be necessary if he cooperates in the investigation, for fair completion of the investigation of Govardhana PS case number 68/2025. Stop. In view of above discussion, the above named petitioner is allowed to go on bail of rupees 30,000 with one security of like amount, subject to the satisfaction of learned
Chief Judicial Magistrate Baksha Musalpur.
Baksa,
Baksha Musalpur.
Chief Judicial Magistrate Baksa Musalpur, with following conditions. Condition number 1 and 2. This bail application is accordingly disposed of.
Last may I kindly add one condition, my lord, please shall refrain from doing such type of activities in future. Otherwise, my lord.
Now we don't know what he has done, whether it is before. Let the investigation go.
And that should be a condition, my lord, because
This condition gives an impression that I am believing prosecution's case. That is not necessary at this stage.
Item 6.
Please, Your Lordship. I'm in custody for 115 days and seized has been ganja, 30 kg of ganja. Now, Lordship.
115.
Lordship. 26/3/2025, I have been arrested, Lordship. Lordship, they kindly come to annexure number 3, page number 16, Lordship. I think
The investigation is going on.
investigation is going on, Lordship.
Case diary would be this.
Lordship. But Lordship, may I kindly see I will be on annexure number 3, page 16. That is the ground of arrest. Nothing at all has been mentioned.
When can you produce the case diary?
Nunmati, please.
Heard Mr. A. Bhattacharya, learned counsel for the petitioner. Also heard Mr. M.P. Goswami, learned additional public prosecutor. Considering the nature of offense involved in this case, as well as grounds on which the bail is sought for by the petitioner, perusal of the case diary would be necessary. Stop. Hence,
The original certified copy.
hence there may be other document apart. Hence, let the case diary be called for. List this matter.
After about 1 week, madam, any day.
28.
28.
28. List this matter on 28/7.
Item 7.
Heard Mr. What is your name? M. Rahman, learned counsel for the petitioner. Also heard Mr. MP Goswami, learned additional public prosecutor, call for the case diary. When?
8th of August.
Let this matter be listed on 8th of August. Yes.
Item 8.
My pleasure, Your Lordship. My lord, in this case, Your Lordship, 21B NDPS Act has been implicated, Your Lordship. But my lord, this section totally not covered in this case, Your Lordship. As per election, Your Lordship, kindly come on page number 31, Your Lordship. Is the water of my lord, CGM, Nalbari, Your Lordship. After waiting this suspected hearing, Your Lordship, only 1.42 gram is recovered from the petitioner, Your Lordship. And my lord, the suspected hearing, Your Lordship, were recovered from the from my behind of the house, Your Lordship, not from my position, Your Lordship. As per Caesar list also, Your Lordship. The second paragraph is relied upon, Your Lordship. The suspected powder is substance from all the 15 small plastic containers is poured into a transparent plastic pouch and then on weight. The weight of the seized contraband is found to be 1.92 gram, including plastic pouch. The said plastic pouch is weight and same is found to be 0.50 gram, and hence the net weight of the seized suspected heroin is 1.42 gram. The plastic was is filled.
Where are you reading?
Page 31. Page 31, Your Lordship. So, my lord, it is a small quantity, Your Lordship, and I am a lady, Your Lordship.
Then why your prayer was rejected by the trial court?
No, my lord, it is not a rejection order, Your Lordship. It's a production order.
Where is the rejection order?
Rejection order,
Wha-
I think I did not apply for bail, Your Lordship, earlier.
No, thinking will not do. You have to be certain whether you have sworn an affidavit.
Yes, my lord.
Why have you not approached the trial court when it is only 1 point?
In affidavit, there is no any mention, Your Lordship. So I have no information about this, Your Lordship. So, my lord, already, Your Lordship, 24 days.
No, that is not my question. You first cross first hurdle, then we will consider your case on merit. What have you stated in your affidavit?
In affidavit, I am the father. Affidavit.
You find out whether you have filed an application before the trial court or not.
Then I have to inform, Your Lordship.
Yes, you take information.
Sometime.
Okay, we'll take it up after some time. You take information.
Okay, massively.
Item 26 from supplementary list.
Please, Your Lordship. My lord, I am put 64 days in custody, Lordship, as on today. And as per his Lordship's order dated 17/7, I have filed the additional affidavit, bringing on record the rejection order, Lordship.
Okay, what is the offense?
Offense, Lordship, allegation is that I made some objectionable comment on social media, Lordship. Lordship may kindly find the FIR at case 8.
How much is the maximum punishment?
152 is their, Lordship. And the 152.
90 days.
Lordship. 64 days as on today, Lordship.
Where is the FIR?
FIR, Lordship, may kindly find that case 10, Lordship, relevant case.
When all the people in grief relating to the Pahalgam issue, my lord.
what he has, where is the objectional post?
Wherein profile has been given.
62 days is long enough. What has he stated?
We stated that in the page 12, my lord, grounds of arrest. Pakistan Zindabad.
Only Pakistan Jindabad. Anything else?
It is not in details, my lord, otherwise it has to be.
No, from the FIR, it appears that he uttered only Pakistan Jindabad, I love Pakistan. How it? Where are the ingredients of 152? Suppose somebody says Russia Jindabad. Whether it will be, you have to
Don't have any enmity at that point of time.
therefore I am asking you how the ingredients of 152 are fulfilled.
That burning if you Pahalgam, whole country is that dealing with. At that point of time, if he is saying that love Pakistan and by the social media, it will go to.
No, apart from that, he has to utter some more other words, which may be
As per my understanding, that is sufficient. If he is uttered that word only, and it will go to thousands of people, I think, in a minute, through social media.
But he is not that
No.
influential person also.
he has to,
At this point of time, that CD may be called for, what the CD reveals, and details of the post is not with us, at this point of time.
yes. What else you have uttered?
Lordship,
That endangering sovereignty, unity and integrity of the India, unity and
Yes.
integrity, yes, if he by this act, thousands of people will support him. We don't know from the URL, how much people like him, we don't know at this stage from reading the
Lordship,
FIR.
kindly see, I have,
Maybe thousands of people like in
I
his
have
post,
stated-
Today is the first day, okay.
Lordship, may kindly.
Otherwise,
It may.
60
apparently from FIR, it is not a case where you can detain him for so long for completing the investigation.
Yes, but he has come late and CD is not before us. There is a motion day, if thousands of people like we don't know whether like or not. Maybe it can be revealed only from CD.
Heard Mr. M. I. Hussain, learned counsel for the petitioner.
Rejection order also, no.
Lordship, may kindly enlarge me, considering the length of detention.
Where is the rejection order?
Lordship, may kindly additional affidavit of it. Page 15. Page 15.
Ingredients of 152 has to be there.
That is not their lordship. The ingredient to constitute a commission offense under section 152, there has to be anything, something endangering to. the
Otherwise
security
also
of the-
60 days long enough a time.
Yes, lordship.
Otherwise also for,
My contention is that my prayer is that, only the URL is there, by the URL we cannot, we are unable to know that what else, how many people support.
No.
Maybe thousands, it can be revealed only from the city. If thousands of, only Pakistan, only that line, thousands of people may like him. It can be revealed only from the.
no, but whether it constitute an offense, that is my question.
If thousands of people with him, then it can be unity and integrity, maybe. So,
Lordship, may kindly see what I am I.
what else
I have
not?
stated
Act
paragraph two,
endangering
lordship.
sovereignty, unity and integrity of India,
Lordship, may kindly see paragraph 2, what am I, lordship? I am a labor.
Heard Mr. M. I. Hussain, learned counsel for,
This honorable court for the first time, siren was called and we mourned for that incident only.
no, those are different things.
Yes,
My
sir.
query is legal query.
Yes.
Whether it constitute an offense under one,
that point of time, he made that statement. When the whole country is in this, my lord, at that point.
That
of
is not my query. My query is time.
my
An,
lord,
an off,
read
an,
from the CD.
an offense will be an offense at a particular time. It may not be an offense now. Suppose now somebody utters these words, Pakistan Jindabad, I love you, Pakistan. Will it be an offense under section 152?
If that is not, that he has not uttered in simple manner, he has uttered in the social media. In social media, thousands of people may at a single, at 1 second, thousands of people may like him, my lord. But that can be revealed.
When can you produce the case
And
diary?
now I do not use this mobile also. That number is
That,
not with me, Lordship.
that is not.
Lordship may kindly say.
Those are not my queries.
Yes, sir.
Lakshmipur-
Legal queries, Lordship, the offense does not constitute,
By Wednesday, my lord,
the
I
act does
don't-
not constitute offense under 152.
Okay.
This is not a submersive activities, Lordship.
No, apart from these words which are there in the FIR, if there is no other words,
Lordship,
apparently it appears that it is not an offense under
correcting me,
152.
before 3 days of arresting me, the mobile was seized by the police. And after 3 days, after making inquiry, I am arrested. And the police
Yes,
has
that
lodged
means-
the FIR that I have said, I love Pakistan.
That means.
That is there. If
there may
there
be
had been
something.
there something more, the police should have mentioned that in the FIR also. That is not there, Lordship. That is not there. Because that due to the prevailing situation at that moment, and for making this statement, I was arrested, Lordship. Nothing more is there,
Heard
Lordship.
Mr. M.I. Hussain, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 483 of BNSS 2023 has been filed by the petitioner, namely Abdul Rashid alias Rashid Mandal, who has been detained behind the bars since 18/5/2025, within bracket for last 64 days in connection with
Sorry, only one line, just and pointed, my lord, in the FIR itself, my lord, just one line. During the course of inquiry, it is found that the comment made by the accused person portrays that he is happy with the killing of the innocent people in Pahalgam as terrorists. Through his comments, he even justified that interest of the terrorists into the social media account, my lord. That is,
now whether there are other comments.
no,
This is the interpretation of the informant.
yes. Yes, ma'am. That is the interpretation.
Yanika? Okay, when can you produce the case diary?
64 days is.
Lakhimpur, by Thursday, my lord, next Thursday, my lord. From Lakhimpur, my lord. The 5th, I think.
Enough time, Lordship.
No, something is it?
54 days, I have
It has to be dealt with whether such utterance is an offense or not. And therefore perusal of the case diary would be necessary.
24th, my lord.
what I have uttered already, that is
We
mentioned in the
will
document.
we will peruse the case. क्या लिखा? Who has been detained behind the bars? Stop. Learned counsel for the petitioner has submitted that the petitioner is alleged to have posted and uploaded a post in where Facebook.
Facebook account, yes.
In his Facebook account.
Illiterate person, all these.
No, don't interrupt in
Sorry, Lordship.
Facebook account. A post that is within inverted comma Pakistan Jindabad, I love Pakistan. He stopped. Learned counsel for the petitioner submits that mere uttering the mere posting of the post as has been alleged in the FIR does not constitute an offense under section 152 of BNS, and he submits that for other offenses under which the case has been registered, the maximum period of detention is statutory detention is 60 days under section 487 of BNSS. On the other hand, learned counsel for the petitioner submits that on the other hand, learned additional public prosecutor has vehemently opposed the grant of bail at this stage and has submitted that the post uploaded by the petitioner in the Facebook account does constitute an offense under section 152 of the BNS. He also submits that at this stage, case diary may be called for, since this case has been listed in the motion column today. Stop. I have considered the submissions made by learned counsel for both the sides. This court perusal of the case diary would be necessary for consideration of the fact as to whether any offense under section 152 of BNSS has been committed by the petitioner in this case or not. Hence, call for the case diary. Let this matter be 24/7. You come with judgments.
Item 27.
We'll take up together.
Item 28.
May I please? My lord, the petitioner is a lady, my lord, and he has been arrested, my lord. Today is the 4th day of his custody, my lord. What happened, my lord? Lordship, kindly turn to the
What is the offense?
offense is basically, my lord, gambling. Basically gambling, my lord. She used to look after the one resort. She used to supply the flowers and the decorative purpose, and also in the vicinity, she used to go for the cleanliness and her basic, that's her activities in that particular resort, my lord.
She's not the owner.
She is not the owner as alleged in the FIR. I have given the papers also. Now what happened, my lord? 3-4 persons from Mizoram, they have booked the resort for some purposes, my lord. And from their, inside their room, that is the room number, my lord, in the FIR also specifically indicated, some gambling machinery and some tools and some poker coins has been recovered, along with some other items, my lord, inside the rooms, my lord, from the 3 rooms. Then the police apprehended those persons along with me and my husband. Husband is no way connected. He just went to visit me in the police station. He is also picked up. The lordship can see the page 15, the FIR.
Yes.
With the reference of cited, I have honor to report that the today at so-and-so around so-and-so, in charge of the Sonapur police station, received information a reliable source, some illegal gambling activities were going on. So-and-so places
Accordingly, the officer in charge has made a general entry, GD number 14/157. Accordingly, police team led by the officer in charge, including the Industry Dahal, ASI, Chief Duty Nath, and other staff members, including the myself, proceeded to Club Nirvana Resort, so to take the necessary action after reaching the resort. And in accordance with the received information, premises were searched in presence of the independent witnesses. Before conducting the search, officer in charge verbally directed me to take necessary legal action regarding the search and seizure if any illegal gambling materials were found. For the purpose of the search, and the following 3 persons were requested and agreed to act as independent witnesses. Now, these are the 3 persons. The search was started at so under the leadership of the so Sonapur in presence of the above witnesses. During the search, room number, this is important, my lord, 1, 3, and 9 and 8, 1, 3, and 8 on the first floor of the old building of the club. Following the individuals were found. These are the items recovered, my lord. Some liquor bottles, iPhone. These are the recovered. All items were recovered in presence of the witnesses seized by me, as they are found to be used in illegal gambling purposes, my lord.
Which item is used as in illegal gambling purpose?
My lord,
iPhones.
they have not iPhones, my lord. But later on, my lord, some coins they have also recovered, the poker coins. The iPhones, then the liquor,
Casino poker chips. Okay.
later on the
Casino purchase by default illegal.
but the casino poker chip is not an illegal item, my lord. The accused person was brought to the so-and-so, seized article and kept in the PS. Later, the owner of the so-and-so were also brought to the police station for interrogation. On the completion of the formalities, detailed as follows: Jyoti Sharma, so-and-so, Abhishek Sharma, Deepak, he is the husband, Deepak Shaikya, he is the manager, my lord. He used to run the entire day, admittedly, my lord. So these are the 4 persons also apprehended from those 3 rooms. During the search, following articles suspected to be used. Now suspectedly used, my lord, Lordship kindly mark, for illegal gambling for recovery of the same for their respective rooms and personal possession. So these are the all items were found inside their respective rooms, my lord. And a lordship knows when person books a particular hotel room, it's become his sole property, my lord. Even in there are lots of judgment without even the warrant, a person cannot enter into, even the police also cannot enter into. And there are lots of cases in NDPS cases regarding that formality. In the night, there has to be, because he becomes the owner of that particular room the moment it was booked under his name, my lord.
It is no longer a public place.
Because it's no longer a public place, madam, once he booked the hotel room. That has been decided by the Supreme Court in Katana judgment, madam. Now, these are the items specifically which was found inside their rooms. Some 210 numbers of casino poker chips of various colors using in gambling. Then 2 numbers of empty casino poker chips cover, 7 numbers of card deck, brand name so-and-so, 8 numbers of poker dealer button using the gambling casino. So it was, they have not caught red-handed while playing the gambling. They're simply, these items were found inside their rooms. Now, page 17, my lord, next page. Now, what they did, my lord, it has been found that the above named accused person, in collusion of the owner and the management of the club Nirvana Resort, has been involved in running the illegal gambling activities for their wrongful gain. The 4 accused persons in Mizoram were being provided shelter in the necessary facilities by the club authorities to carry out those unlawful activities, in which included the consumption of alcohol, tobacco, and other criminal acts such as human trafficking. Now, where from the human trafficking comes on, my lord, that's we know. Not a single person was apprehended, rescued by the police, admittedly. During the course of inquiry, it has been come to the light that the owner or the manager of the club Nirvana Resort were involved in the illegal business of human trafficking. They allegedly procured girls for supplied them within the resort premises. Now, Lordship can see if that be this, then the first requirement is to register the case under the Immoral Traffic Act. But they have not registered the Immoral Traffic Act. And not a single girl has been recovered from that particular place who has been, my lord, who were exploited by the owners, because the requirement is only recovery will not do, there has to be exploitation of those girls. Here, nobody was recovered, only because in the later stage also, it is only they have said in the notices, it will come clear, my lord. They are only assuming there's a possibility of the human trafficking. In the FIR, though they have said, in the notices, they have admitted there's a possibility.
Why your prayer was rejected by the,
My prayer was rejected.
where is the rejection
Yes,
order?
yes, madam. Nothing. My whole submission was recorded by the learned magistrate. Even if the magistrate also silent, though I have specifically argued.
Paragraph 26, 27 are her reasoning.
Paragraph 27 and 27 are her reasoning in this case. For Paragraph 27, 26 and 27. Though there is a specific argument that nobody was, because as per 143, trafficking of a person, there must be at least one person must be recovered from the premises who has been exploited by the authority. Now, our allegation is in the CD that from the possession of the manager mobile phone, some photographs they have found. Whether the photograph will create an offense, madam. Carrying the photographs.
That too in manager's personal
That too in manager's personal mobile phone. If I carry, if my driver carry, if I carry, whether my junior will be arrested for that purpose, that your junior carries the photograph of the lady. Woman. So they might have exploited minor. This is the case, madam.
That too we are not the owner also.
And that too, my lord, we are not the owner, my lord. And there is
But perusal of the case diary may be necessary.
my lord, in this case, I am only for the, my lord, absolutely she is not involved, my lord. Apart from there is a strong medical ground, that's why I am praying, my lord.
What is the medical ground?
Medical ground, she recently had a miscarriage, my lord. And she was suffering from lots of, my lord, trauma.
Where is your forwarding report?
That's the same forwarding report, my lord.
Okay.
All forwarded, nothing specific.
What is your name? Jyoti Sharma.
Yes, my lord. And the lordship now, before that, lordship kindly see this, who are the owners. And before that also, lordship kindly go by the.
No, what is the accusation against you?
Nothing, my lord. Specifically nothing. No specific accusation, my lord. It's a omnibus statement against the, initially they have found the poker and they have alleged because of they have found there's some photograph in the manager's mobile phone, then there may be, now lordship can we take page 25. That's very important. The notices issued to me, my lord, that's very important. Here also, the allegation against the Deepak Sharma in the entire notices, not against me, the manager.
48 notice. 47.
47 notice, page 24.
Okay.
It is against those 4 persons and the specific against the Deepak Sharma, the manager. Now, page 25, point number 7, that's very important. Sorry, my lord, page, point number 8. That is my exact role. Point number 8.
Yes.
The role and involvement are amounted criminal conspiracy aimed at promoting, organizing illegal gambling and possible trafficking. just because of that matter. I have been forwarded, possible. In the, because, my lord, what happened, my lord, in other, if they register the case under the Games and Betting Act, it's a 3 years imprisonment. If they register it under the Immoral Traffic Act, it's a maximum in 7 years. Until and until this minor is procured, my lord, then 10 years, my lord. So, to bypass those, because then the 41 notice, 35 notice is required. To bypass that, they have added this particular section, which is a 10 years punishment.
Which one?
The 143. And the 317, it is the stolen property. Habitually with stolen property. The section 2, they have incorporated, one is the human trafficking, and the second was the receiving stolen property. Regarding the receiving stolen property, Lordship has seen, there's an absolutely, they are silent about it. Why they have incorporated that particular section, I don't know. Where from that, absolutely nothing. And now the human trafficking, my lord, the first requirement is that there has to be one, at least one person. One exploited individual must be there. That's the requirement. Here nothing as such. Just to bypass, this is what we call, my lord, the Supreme Court call, it is a judicial camouflage.
What is your medical urgency?
My medical urgency is that recently I have undergone a miscarriage, my lord. And apart from them, there is some suicide attempt, my lord. Then after that, and also, my lord, right now, I am having this kidney stone and I am suffering from severe pain, my lord. And my recent that then again they have tried to conceive. She might have conceived also now after that. So my prayer is that I am asking for an interim prayer, my lord, at this stage for her only. And Lordship kindly see the records that very important. The page 33. That is the Ministry of Corporate Affairs. Who are the owners, my lord? I'm not an owner, my lord. These are the two persons, they are the owners, my lord.
Who are you? You are employed.
Yes, my lord. They are the owner, my lord, of that resort. I am just looking after the supply of flowers, basically the hygiene part, supply of flowers and the cleanliness and
Yes, Mr.
so
Sharma.
I am at this stage only with a folded hand trying for my lord interim bail, considering his
No.
medical.
No, where is that medical urgency? Show me.
That's my lord. She has recently gone for my lord. That is
Miscarriage.
miscarriage.
Where is that?
Page 63, my lord. Just 60 days ago, my lord. Then, my lord, Lordship kindly see.
That is 60 days ago.
And
That
then
may not
yes,
be.
She has suffered a lot of mental agony, my lord, because of the miscarriage. And I have been told there is an attempt on her part to commit suicide after that. But that apart, my lord, the next one is more important, my lord. Page 64, then now calculus has been found in her kidney. It's a kidney stone, my lord. Cannot be operated at this stage because she is because of the miscarriage. These are the complications that she is suffering from. And the Lordship has seen what the clerk did. This person has booked it, page 26. Officially, he has booked it, paragraph page 26. Now, we have provided, and Lordship can see page 26. He is the person who has apprehended for one particular room that has been mentioned. And for the purpose of my lord, the purpose of use, we have specifically said no unethical purpose you cannot use, no immoral activities you cannot use. Now, the page 28, they have booked it, they have paid 3 lakhs of rupees. Page 28, paid 3 lakhs of rupees in the column number 5th by booking. Now, next, on that day itself, we have supplied all the details of all the boarders who have booked by those 4 persons to the police, the case report. all the four person to the, that's the requirement of the law. This is the uploaded in the police website. These are the requirements.
Yes, Mr. Sharma. The grounds of arrest
Yes. And
against her, there is, what is the accusation?
Yes, Lordship will kindly come to the forwarding at page 19. I will skip the first two pages, Lordship.
Yes,
Yes, Lordship will kindly see point number 2. Answer whether point. I will skip the point number 2, Lordship. Lordship will kindly come to point number 3.
point number,
3, Lordship. I am skipping the point number 2 because it relates to the seizure of the poker items and machine that was seized from the
Okay.
rooms. 3 number. That sir, the case is a very sensitive and important in nature, having widespread ramification, wherein interested gamblers, human traffickers are involved. It is also found during investigation that the accused are from Assam and Mizoram. They are professional and illegal gamblers involved in running, supplying logistics for gambling tools, providing funds, engaging a huge number of youth of the new generation towards so-and-so. Point number 4. The accused persons, namely so-and-so Lordship, they are the persons who are from Mizoram. They are found to have been sheltered and facilitated in the resort premises by accused Deepak Boiso, who is the manager of the resort, and the resort owners respectively Jyoti Sharma and Abhishek Sharma for their wrongful and illegal gain in connection in the instant case. Point number 5. During the investigation, it has been revealed that the arrested accused persons Deepak Soikia, manager of so-and-so, has been involved in human trafficking activities in and around the resort premises as well as in Guwahati, in collaboration with its associates and in connivance with the owners of the resort. It has come to light that during investigation, both the resort owners, Jyoti Sharma and Abhishek Sharma, were aware of trafficking and the supply of girls to the resort and nearby lodges. Such activities send a harmful and immoral message to society. A screenshot of conversation involving the accused Deepak Soikia, along with some obscene photographs, have been enclosed here with so-and-so. Now, Lordship, point number 6. Now, Lordship, coming to
no,
the rejection order. Lordship, kindly take up the rejection order for a moment. The court, concerned Lordship, has gone through the case diary.
at page,
At page 26, I'm sorry, Lordship, paragraph 26 and 27. Lordship,
That
kindly take
which
up.
I have already pointed out.
uh,
I'm just stressing on the point, Lordship, paragraph number 27. I am also of the considered opinion that this is a nascent stage of investigation. And there are prima facie.
when can you produce the case diary? Case diary would be
Yes,
necessary.
Well, only on the point of my medical, my lord, kindly consider.
Medical is,
Miscarriage, my lord, and she is not the owner, my lord, admitted.
no, to appreciate that,
They are not the owner.
case diary would be
They
necessary.
are not the owner, my lord. I have given the paper, my lord, which is from the paper logical, it's a Government of India, Ministry of Corporate Affairs, my lord. It shows who are the owners,
No,
and they are showing me as an owner, and what they have found, my lord, only the photographs of some girls in the mobile phone of the manager. So they are apprehending, and the notices says there may be. And the 143, where is the single victim, my lord? The section, my lord. Where from they have come to a
when
conclusion.
can you produce the case diary?
Lordship,
Short date,
28. Monday.
20, we have to produce the case diary. Heard Mr. A.M. Bora, learned counsel.
Of that, my lord. It's from the Guwahati, my lord. It's just a
When?
day. Next week, my lord.
Yes, next week,
Tuesday, my lord.
Tuesday may be difficult,
So Wednesday, my lord.
Wednesday. Heard
Why-
Miss,
why-
heard, which police station? Which police station?
From Sonapur.
Well, can it be?
Wednesday.
Wednesday. Okay.
Heard Mr. A.M. Bora, learned senior counsel assisted by Mr. D.K. Bodleo, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. Considering the nature of accusation made in the FIR, as well as the fact that the prayer for the bail of the petitioner was rejected by the trial court after perusal of the case diary, comma, this court proposes to peruse the case diary before, for considering as to whether the petitioner is entitled to get bail or not. Let this case be, let the,
I'm sorry, Lordship, I'm very sorry, Lordship. Lordship, I've given a paper, Lordship, kindly takes up that paper. This is, Lordship, given by the IO of the Sonapur PS case, Lordship. Here, Lordship, as per the court's order, Lordship, interrogation is going on even now, Lordship. So if Lordship kindly grants us some time, Lordship.
she is in police custody.
The court below has granted us permission to interrogate her even in judicial custody. Lordship will kindly take up the paper. Last paragraph. Lordship will see- during
No,
the
let
court-
the interrogation goes on.
During the course of investigation, it is essential to interrogate the accused for purpose of collecting further evidence.
There is no bar in interrogation. Interrogation
Yes.
may continue.
That is-
We want only case diary. Let this case be listed again. The learned additional public prosecutor shall produce the case diary on the next date fixed. List this case on Wednesdays,
And my lord, on 23rd.
23rd July. Also produce the, yes,
If the case there is not come, then my lord, on medical ground, my prayer may be considered on next day.
and let also the health status report of the petitioner be called from the, where she is detained,
He's in the custody, central jail.
from the superintendent of Central Jail Guwahati, before the, so as to reach this court before the next date fix. List accordingly.
Item 29. May I please, your lordship? Lordship, 19 days behind the bar for 3.8 kilogram of suspected beef, lordship. And lordship, they are not also the owner, they are only employee of the hotel, lordship. Main owner is Nazrul Alam, the elder brother of accused number 1. And
How many days you are behind the?
19 days, my lord. On 1st of July arrested, 2nd of July forwarded, and today is lordship 19.
Where is your rejection order?
Rejection order, I have not annexed, lordship.
Why?
Certified copy is there.
No, you have to annex it.
So lordship, what happened? Thereafter, they went to session judge's court. That order is not with me, but all the certified.
Even
copies-
session judge also rejected it.
No. Yes, lordship, yes, that's why.
You know the rules. The requirement is when you file a bail application,
That is
the
rejected.
rejection order is to be annexed along with the,
It is rejected, lordship. Thereafter, we have filed immediately. We have filed here, lordship.
no reasons. If it is rejected, it has to be there. Challenge that rule, which requires you annex the rejection orders. Otherwise, you are not following with the rules framed by this High Court. Mr. Chamua,
Lordship, this is the order of rejection.
no, bring it on record, not in this way. We'll take it up on Monday. Otherwise, nobody will follow rules. You are there to ensure that rules are followed. Therefore, a council is engaged in a case.
Permit, we can produce the case that we like the case be fixed on Wednesday or Thursday. It's approving a law.
Otherwise, period of detention is enough.
19.
They are
days,
entitled to get bail
Monday.
Monday.
Lordship, 19 days already behind.
Yes, but he has to remain behind the bars because you are not following the rules. Heard Mr. G. Sama, learned counsel for the petitioner, who prays for allowing the petitioner to file an additional affidavit to bring on record the rejection order of the bail by the trial court.
Obliged, my lord.
The prayer is allowed. Let this case be listed again on 21st of
Obliged.
Item 9.
May it please your lordship.
where is.
Am I audible, my lord?
You are audible but not visible. Just a minute. Yes.
Now I'm visible, my lord?
Yes.
Your lordship, this is a matter which I
Kiman,
will demonstrate. That is a classic case of abuse of the stringent provisions of the POSCO Act. The fact is that before I take your lordship to the FIR and all. The petitioner before your lordship is a headmaster of a school, Others Higher Secondary School in the district of Golaghat. So what happened is that an allegation was made that on 31 May 2025, I, under the pretext of giving tuition, carried out some indecent acts with the complainant's daughter, who happens to be a minor. Now, on the basis of that incident of 31/5/2025, the FIR was lodged on 9/6/2025. My lord will kindly come to the FIR. That is at page 14, annexure 1. My lord is there?
Yes.
Your lordship, I am reading the FIR. With due respect, I would like to inform you that a person named Sri Jiten Soikia, who is the headmaster of Ultajan Adarsh Ushya Madhyamik Vidyalaya in Ultajan village under Morongi Moza in Golaghat district, on 31st May 2025, Saturday, after school hours, Headmaster Sri Jiten Soikia came to informant's residence with a pre-planned intention to molest the daughter of the complainant, a class 9 student, and pretended to teach her mathematics at 1:40 p.m., touched the private parts of the daughter of the informant and attempted to commit a heinous act. When she shouted, the accused Sri Jiten Soikia covered her mouth and threatened her, saying that if she reveals the incident to anyone, he would ruin her life and fail her in exams and issued various other threats. Therefore, I inform and request you to take legal action against the headmaster Jiten Soikia, who is involved in a sacred institution like a school, for attempting to commit rape my 14-year-old minor daughter, threatening to destroy her academic future and committing heinous crimes like mentally torturing and academically obstructing the student. In pursuance to this, my lord, the concerned police station registered the case against me under Section 10 of POSCO Act and Section 75 of the JJ Act. Now, your lordship will kindly come to the FIR form. Your lordship will be there at page 18. My lord is there?
Yes.
Page 18. Your lordship will kindly see the serial number 8. Reasons for delay in reporting the complainant or informant. By delay by the complainant, reason for the delay. That column has been kept blank because they could not give any justification why that there was a delay. Now, kindly come to the one, annexure 2. Annexure 2.
Page number?
This, page number 21.
Yes.
I am very much concerned with this particular document. This is a representation made by the public to the Honorable Commissioner of Golaghat District. And the vernacular version is also there. I'm reading from the typed version. Request to implement the decisions of the public meeting. Sir, with due respect, we would like to inform you that a public meeting was organized on 12/6/2025 at the premises of Others High School, Ultajan, in response to certain controversial issues that have arisen between the headmaster of the school and a female student of class 9. The meeting was called by the Palgani Anchalik Student Union, Murphulani sub-branch of various organizations called up. After listening to the views of various organization leaders, local dignitaries, and former students, the meeting unanimously adopted a few resolutions. We are submitting those resolutions for your information and requesting you to take necessary action. Resolution number 1. The meeting unanimously resolved that the highest authority should conduct a proper investigation into the situation that has arisen between the headmaster of the school and the student and my lord will kindly appreciate that this thing that I have referred to Annexure P2, where the resolutions have been passed that media has
20
taken up this thing.
I have considered those. 25th.
25th of this month.
It's from Golaghat Lordship.
Can it be preponed, my lord? Scan copy. Because
20
my other employees are not getting anything.
25th of.
Obliged.
of July.
Obliged, madam.
Item 10.
My lordship, similar kind of allegation, my lordship. 4 months delay in lodging the FIR. FIR is on page 12. This is the third bail application. Page 12 is the FIR, my lordship.
Third bail investigation is going on. Is
Yes, my lordship. This is third time may I read the FIR?
no. What is the fresh ground?
Yes, my lordship. Annexure,
We are calling for the case diary.
Annexure 4.
Heard
Next
Mr. S.B. Laskar, learned counsel for the petitioner. Also heard Mr.
Also POXO.
D.P. Goswami, learned additional public prosecutor. In earlier case, issue notice to the council is present.
No
In earlier case, issue notice to the
Please, your lordship. Actually, to the bail lordship, and the FIR is at page 10 lordship. May I read the FIR lordship?
yes, what is the offense?
Offense is regarding under Arms Act lordship,
25(1)B lordship.
25(1)B. But arms has not been recovered from me lordship. From those who has been recovered, they have already been arrested lordship.
Okay, there is required lordship.
What is the accusation against you?
Lordship, accusation against me is at paragraph 2 of the FIR lordship. During interrogation, so and so admitted that both of them, along with their accomplice, Joten and Onsula is the petitioner lordship from Sirang district, and one so and so had together in their criminal conspiracy poached a wild elephant in Kalazhar under Nonai forest range under Paneri PS around
Case diary would be required. Case diary would be required. Heard Mr. D. Chaudhary, learned counsel for the petitioner. Also heard Mr. D.P. Goswami, learned additional public prosecutor. Perusal of the case diary would be necessary for consideration of the instant bail application. Hence, call for the same. List this matter 5th of August.
Udalguri.
31st July.
Much of it.
Item 12.
May I please your lordship, 482 anticipatory bail application, NTPS commercial quantity, your lordship, FIR is at page number 11, your lordship. May I read the FIR, your lordship?
Yes.
Baihata Sariali PS GD entry number. With reference to the subject cited above, I have the honor to report that on 6/3/2025 at 1:10 p.m. information was received from reliable sources that a drug peddler, namely Boga, that is alias Nazir Kazi, son of Aftas Ali of Baihata Sariali Police
22C.
22C, 240 of bottles were recovered, your honor.
You are named in the FIR.
I am named in the FIR only because there are previous antecedent of mine being involved in intermediate quantity of NDPS.
Case diary would be required. Heard Mr. T. Laskar, learned counsel for the petitioner. Also heard Mr. D.P. Goswami, call for the case diary. List this matter on
Highway 24.
5/8/25.
Much obliged, Lord.
Item 13.
Please, your lordship. It is therefore creable under 482 B and SS. My lord, in a special hunting case 222/222/2024 corresponding to Kazino PS case number 10/2019 under section 120B so and so of Indian Penal Code yet with section 4579 of Assam with hunting.
Which hunting?
Your 2 years also there.
My lord,
Where is the affair?
if I
What is your name?
My name is-
Sapatrabha.
Poteswara, my lord. And they are all aged person, my lord. They are not involved in the case. They went there as a stranger to settle the dispute, but for the implicated in that case, my lord.
But you are named in the affair.
My name is in there. My lord,
We'll call for the case diary.
my lord, kindly, give me submission. The Sapatrava is 86 years old and Poteswara 83 years old, having always an medical treatment. And afterwards, my lord, because I filed bail petition, there is no case against them in the affair, but as they have been named in affair, which is reasonably along with many other villages, as yes, bail petition was moved before the honorable court, maybe so and so rejected and ordered with the objection that the custody of the petition would be recorded for the purpose of investigation. The said bail petition was moved during COVID pandemic. Page 23.
Your earlier bail application was rejected.
Yes, my lord. Afterwards, investigation is going on.
Where is that rejection order?
Huh?
Where is that rejection order?
23 to 25, my lord.
No, where is it? Which is the page? Page number.
Page number 23 to 25.
Now whether investigation is going on.
Still going on, I was not arrested. 41 under section 41A CAPC to the petitioners on auto. The investigating officer himself came to the residence of both of the petitioners on but has not arrested them as there was no prima facie evidence of their involvement in the alleged incident, and perhaps also in consideration of the age and only told them to cooperate in the initiation of the case and also interrogated them about the incident. Page 26 and 27, my lord. I am not arrested by the investigating officer.
Then where is the apprehension?
My lord, after all, my lord, someone was issued to me to prepare before the case. After getting someone, my lord, I
Summon or notice?
someone notice. Page 6.
Summon or notice under 41A.
41.
Okay.
Page 26 and 27. That is notice under section 41A of
Yes.
CPC.
You appeared before the investigating officer. Thereafter,
Thereafter, my lord, charge sheet was submitted. Charge sheet. In the charge sheet, my lord, kindly 6 page 55 and 56.
this is a charge sheeted case. Charge sheet has been filed.
Charge sheet has been filed. Charge sheet, in the charge sheet page, kindly see, my lord, page 55 and 56.
No, what is your submission? You have received summons from the trial court? Yes or no?
I have received one sound call. I appear my learned counsel appeared with the court on 3 June, plus 3 June. And next day got finished on 13 July. My lord, order this, my lord.
Yeah.
And see page 66, para 2. Order. My lord, this PSBL is
Page,
before this,
page
66, my lord. Para 2. That is order, my lord. Para 2. Since the petition number 8058 of 2005 filed by the engaged council for the accused Sapat Raba and Patasya Raba, stating that the cause
No, court has allowed your adjournment prayer and fix it on 37. Now, where is the apprehension?
the imprisonment, I may be, it is my fear, my lord, maybe
Your fear is,
my fear, my lord.
fear does not have any basis.
Protection, my lord, I only appear and move the case, and that, depend the case, that I am not.
There is no apprehension.
This prayer is allowed and praying for another date for their appearance with bail.
There is no apprehension. Heard, Mr.
My lord, maybe, protection may be, my lord.
You have to seek protection from the trial court. Trial court has not done anything which will cause apprehension of that it will reject your bail on the appearance. You appear before the trial court on the next date fixed and pray for bail before the said court.
Right, my lord.
Heard, Mr.
But you am well, my lord. I am old aged person, my lord, 86 and 83. Old aged.
Heard, Mr. A. Das, learned counsel for the petitioner. Also heard Mr. D.P. Goswami, learned additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioners, namely Sapat Rabha and Poteshwar Rabha, who are apprehending their arrest in connection with special witch hunting case number 2/2024 corresponding to Kozigaon PS case number 10/2019 under section 120B/447/325/307/302 of the Indian Penal Code. The read with section 4/5/7/9 of the Assam Witch Hunting Act. Assam Witch Hunting within bracket Prohibition, Prevention and Protection Act 2015. Learned counsel for the petitioner has submitted that both the petitioners are aged about 83 years, 80 plus years, and they have received summons from the trial court. No, and they were not arrested during the course of the investigation, though they have cooperated in the investigation. Stop. He further submits that the trial court had issued summons to them, summons to both of them, and on 3/6/2025, the engaged counsel for the petitioners filed an application before the trial court showing cause of their absence and praying another date for their appearance, which has been allowed, and the next date is fixed on 30/7/2025. Learned counsel for the petitioner submits that he apprehends that on his appearance before the trial court, it may send them to custody. Stop. It appears on record, from record. I have also heard, no, it appears from record that the court is pending before the special court, court of special judge, Kokrajhar, who has no embargo in considering and granting bail to the petitioner if the case is found fit to be granted bail to them. It also appears that the trial court has issued only summons to them, and even the prayer for adjournment was granted on last occasion, that is on 3/6/2025. there appears to be no apprehension of the petitioners. There appears to be no legal basis on which has caused the apprehensions of apprehension in the mind of the petitioner that they will be arrested if they appear before the trial court. This bail application is devoid of any merit. This anticipatory bail application is devoid of any merit. Accordingly, same is disposed of with an observation that the petitioner may appear before the trial court on the next date fixed, that is 30/7/2025, and on their appearance they may file regular bail application before the said court if so advised. Go before the trial court.
Maybe put it, my lord, considering my old age and I am.
I have already passed order. Go before the trial court.
Item 14.
No problem, my lord. Let me see what should be.
Yes.
Okay, summons are at page 18 and 42. Two summons have been issued.
By the trial court.
No, Lord, by the GST.
Summons was issued from the lordship. Page 18 lordship, annexer B, page 18 lordship, which summons to a paying person and to produce documents. Is Assistant Commissioner of State Tax.
In connection with any offense?
Tax evasion,
That is
Which offense?
that section for 7P of. Yes,
What is section 70?
Goods and Services Act. 70 of, that is 70 of,
What is
70 of the CGST and SGST Act.
CGST and AGST Act? What is that?
We are not a party, we have option.
What is that? What is the offense?
Tax evasion, Your Lordship. Tax evasion.
Tax evasion. Is it prescribes any penalty?
Yes, there are consequential invocation of section 69 and 132 of the section of the Act.
Are these penal section 69 and 70?
132.
What is 69? Power to arrest. No, but what offense you have committed? No offense has been committed. Only summons have been issued.
Yes, Lord.
You appear, there is no apprehension. Merely apprehending that they will invoke power to arrest unless you commit an offense.
They have issued summons to appear before a concerned authority also.
It does not, does it create any apprehension of getting arrested?
Yes, Lord.
How?
The invocation of section 69 and 132, that is the.
Why?
Because the amount alleged is above 5 crores. That is the apprehension.
But they have not invoked that section 69 and 132. It is in connection with some case. Who is appearing for the public prosecutor will represent only if there is a criminal case pending against you. Otherwise, state of Assam has to be. Government council have to appear. What is your submission?
I may be allowed to amend the petition.
Okay. Heard. What is your name?
G.
Heard Mr. G. Rengma, learned counsel for the petitioner. Praise for allowing the petitioner to amend the anticipatory bail application. The prayer is allowed. When?
1 week.
Let this case be listed after a week. In the meanwhile, the petitioner shall file the amended petition. You have to find out, is there any criminal case pending or not? Merely power is there. Power has to be exercised in connection with some case. List after 1 week.
Item 15.
May I please, your lordship? 482 application, my lord. My lord, FIR phase 9, my lord. My lord, I am the, my lord, employee of hotel, my lord. So I have been, my lord, with the police, my lord. The owner of the hotel, my lord, Imran Ahmed, already has been arrested, my lord, and released on bail. And another person, my lord, Farid Ahmed, my lord, team number 1, my lord. He also has been released.
Where is the rejection order?
But, it has been rejected by the Lanet Court of Additional Sessions that I have not annexed, my lord.
That has to be annexed.
Already rejected, my lord.
That has to be annexed. Heard Mr. S.H. Sigdal, learned counsel for the petitioner, who prays for allowing the petitioner to file an additional affidavit to bring on record the rejection order of the bail, which was filed earlier by the petitioner. Prayer is allowed. Let this case be listed
22.
on 22. Second.
Hello.
Item 16.
Another pair, my lord, one clerical mistake is there in the petition, my lord. So maybe allowed to be correct, my lord. I have mentioned it.
Which clerical mistake?
I have mentioned here, my lord, as the, I am the owner, my lord, wrongly, my lord. Actually, I am the, my lord.
You filed an amended
Well-
petition. The petitioner.
The said additional affidavit, my lord, I will put this, my lord.
Okay.
I love this.
16.
I please your lords. Sorry, to application. FIR is at page 11, annexure. May I read the FIR? Page 11, your lordship. I would like to state you that the informant Sri Anantadev Saikia is the resident of Guwahati. I have the plot of land measuring 3.9 lessa, covered by dark number 291, Pata number 142, situated at Lokhin Lenga, under Moja, Bansar, and North.
Forgery.
Forgery, my lord. I am so far, I am the accused number 2. The only allegation is that in the FIR, your lordship will find. So the accused number 1 with the help of accused number 2. So I help, that is the allegation. I help the allegation.
Forgery where?
For the mutation in the name of the accused number 1. Because I am the Lord Mondal, my lord. In this aspect, my lord, this is the allegation as I helped her for mutation. In this, I will submit 2 aspects, your lords. In respect of this allegation, may I take your lordship to page 16. Page 16, my lord. It is height order dated 1/4/15, issued by the circle officer. I was given the additional charge of lot number 6, my lord. Then what happened? Page number 17.
This is the order of release from the lot, from that lot. Annexure page number 17. In the interest of public service and smooth functioning of the office works of North Guwahati Revenue Circle, Siri 1 Purobi Soikia, lot mandal of this office is hereby placed. She was placed and I was released from that lot. And that order was on 12 to 16, my lord. And on page 18, your lordship will find, so far lot number 6, Dokhin Lenga. This is the handing over of charge in respect of lot number 6, my lord, of Bongsor Moja. And so far, the allegation of mutation, that is your lordship will find at page 20. That is mutation order that is on 1/6/2016. So I had no role to play. Prior to that, I was released from that lot, my lord. Because of that misconception, my lords, that allegation against me.
Now, where is that mutation?
Mutation order at page 20. This is the annexure copy, translated copy your lordship will find. As per mutation order dated 1/6/2016. Passing mutation case being case number 1984, so and so, the land measuring, so far the LS mutation. So prior to that, my lord, I was released on 12/2/2016, and that is passed on 1/6/2016, my lord. I was released from that law. That is because of misconception, my lord, that allegation has been made against me. I had no role to play there. 1 Purobi Soikia, she was placed of lot number 6 as a mandal. That is reflected in the order dated page 17, 12.
Okay.
2006.
So mutation order was passed in the year 2016
Yes, my lord. And
and
specifically.
FIR has been lodged in 2025.
And my lord, I have filed one additional affidavit with the permission of your lordship that has come to the record. There, one additional affidavit has been filed today. There I have brought all these certified copies of these documents so far I have referred to. These are certified by the circle officer. These are the certified copies regarding these orders and all. I have annexed here. And one affidavit has been submitted by the informant. That is at page 32. One declaration, that means out of misconception at para 3.
Page
33 in my additional affidavit. Para 3, your lordship will find.
Yes.
So this is the development of the case, my lord, at present. And so far, this it is reflected in the order that I was released from that lot long back, my lord. And the mutation was done on 1.
Yes, Mr. Goswami.
Page 22, lordship, document select by Jamabandi copy, lordship. The right side of the copy, lordship. The third para, lordship. তিনি কথা নলেচা মাটি শ্ৰী অনন্ত শইকীয়া পিতৃ পিতা যোগেন চুতীয়াৰ দখলত খৈৰাই সূত্ৰে শ্ৰীমতী signed by Lat Mondal Girish Majumdar. Petitioner number here, we have the petitioner option. Yes, it is actually computerized. I have stated in my para about that at para 9 in my petition. Because it is a computerized format, your lordship. So inadvertently, my name may be there. But from that, on perusal of the order itself, it reveals that so far that has been certified by the circle officer also, which has been brought in the additional affidavit. Everything is revealed from the case there also. So I pay, but it is a government employment. At present, my prayer is that he may be protected by some interim protection may be granted.
Heard. Mr. What is your name? D. Bora, learned counsel for the petitioner. Also heard Mr. D.P. Goswami, learned additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioner, namely
Girish Majumdar.
Shri Girish Majumdar, who is apprehending his arrest in connection with Baihata Charali PS case number 83/2025 under section 318 within bracket 4/316 within bracket 5/336 within bracket 3/338/337/340 within bracket 2/3 within bracket 5 of BNS. The gist of accusation in this case is that one Ananta Dev Saikia had, on 19/3/2025, lodged an FIR before naming therein two accused persons, including the present petitioner, inter alia, alleging that the present petitioner has helped the mutation of name of the accused number 1 in respect of the land belonging to the informant by forging the signatures of the informant. Stop. Learned counsel for the petitioner has submitted that the petitioner is presently working as Lat Mandal in the circle office of where?
At present, Haju.
Circle office Hajo in Kamrup district. He submits that the mutation which is alleged to have been done by using forced signature of the informant in the informant was carried out on which date?
1/6/2016.
1/6/2016. And on the said date, the petitioner was not
Yes.
looking after the, where is that transfer order?
Page 17, my lord. 1/7.
Looking after lot number 6 under Bongshor Mouza, as he was transferred,
From that.
has he
One Purabi Soikia was
as on 12/12/2016, one Purobi Soikya, Lat Mandal was given the charge of the lot number 6 of Borbangshar Muja, and the petitioner was with, and the additional charge of lot number 6 was withdrawn from the petitioner. Learned counsel for the petitioner has also submitted that in accordance with the order dated 12/12/6 of the Circle Officer North Guwahati Revenue Circle, the petitioner handed over the charge to the new incumbent. He further submits that in the meanwhile, the informant has filed an affidavit wherein he has stated that he no longer intends to pursue with the FIR which, where is that affidavit?
affidavit, additional affidavit, page 33. It starts from 32. There are 3, my lord. Yes.
No longer intend to pursue the FIR, pursue the case which was registered on the basis of the FIR lodged by him on 1/4/2025, as it was lodged under misconception of facts. Stop. Learned counsel for the petitioner has submitted that the petitioner is ready to cooperate in the investigation. On the other hand, learned additional public prosecutor has pointed out that in this computerized copy of the Jamabandi, it is reflected that it was on the basis of the report of the present petitioner, the mutation was done in the alleged mutation was done. Hence, he prays for calling for the case diary. Let the case diary be called for. Let this case be listed again on 14th of August. In the meanwhile, considering the submissions made by learned counsel for the petitioner, as discussed in the foregoing paragraph, the petitioner is directed to appear before the investigating officer of
Baihata
Sareli PS case number 83/2025 within a period of 7 days from the date of this order and cooperate in the investigation. Stop. If he does so within the stipulated period of time, in the event of his arrest in connection with the aforesaid case, he shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions 1 and 2, list accordingly.
Answer.
Item 17.
Let me do it. This is the 42 application, Lordship. FIR is registered under section 319, 336 and 340 of BNS Act. Except 336, Lordship, others are available offense. This sitting and forgery offense. FIR is a page 15, Lordship. It is a vernacular. Translated copy is page 11, annexure A.
Yes. What is the accusation?
Allegation is forgery and
What is your name?
Abdul Ro. He's a managing director of the.
You are named as an you are the named accused.
Named it.
Okay.
False allegation has been made, Lordship.
What is the allegation?
Allegation is a sitting and forgery, Lordship, and they have said that the forged admit card has been issued. I'm not the issuing authority, Lordship. On the basis of if it is forged admit card, they have appeared the SSLC examination, Lordship. On the basis of forged admit card, they cannot appear, Lordship. It is true that, Lordship, the result has been withheld, Lordship. And when the result has been withheld, they did not approach before the SEBA authority, Lordship. Under what reason the result has been withheld? And even, Lordship, from the FIR, it is revealed that, Lordship, last para, Lordship, page 13, Lordship.
Yes.
Our children were called by SEBA, but we did not get any response from the school authority. We wanted to go to approach SEBA authority for the future of children, but we decided to go to SEBA and wanted to know in presence of the authority about the future of the children. Though the school authority did not give any response, but we did not go there. Some people told us that the SEBA authority would arrest the children. They never approached the SEBA authority. Under what reason the result has been withheld, Lordship? On the basis of that admit card, they gave the examination, Lordship. I am not the issuing authority, Lordship. I am running a private school, Lordship. It is no specific allegation against me, Lordship.
Demanded money from.
No, that is the allegation. They demanded money, so and so, so and so, so and so.
After the case there, also, this will be revealed from the case there.
And Lordship, after receiving the FIR, Lordship, the police called the petitioner, and accordingly he appeared before the police station on 25th, 26th and 27th June.
Then
Thereafter this has been registered.
Then
Yes.
why are you apprehending?
No, after that, after appearing my police station, this FIR has been registered, Lordship, with a non-bailable section. So that is my apprehension.
Before filing of the, it was registered on which date?
It is registered on 6/7 of this month, July.
Though it was filed on 16/6.
Yes, Lordship.
Okay. Heard, Mr. What is your name?
Yeah, Ahmed, Lordship.
Heard Mr. A. Ahmed, learned counsel for the petitioner. Also heard Mr. D.P. Goswami, learned additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioner, namely Abdul Rauf Ahmed, who is apprehending his arrest in connection with Tarabari PS case number 27/2025 under section 319 within bracket 1/336 within bracket 3/340 within bracket 2 of BNS 2023. The gist of accusation in this case is that on 16/6/2025, four informants, namely Rumena Ahmed, Binwara Ahmed, Sanbor Ali, and Namita Roy, had lodged an FIR, lodged a complaint before the Superintendent of Police, CM Vigilance Cell, inter alia alleging that the petitioner who is the owner of the school, na?
Yes, Lordship.
Who-
The managing director of this school.
Petitioner, who is the managing director of the within inverted comma Diligent Academy, took rupees 7,000 from each student as fees for transferring the registration, and rupees 2,000 from each student as registration charge for issuance of admit card in which exam?
SSLC.
HSLC examination conducted by SEBA. However, the results of the students were that is children of the informant was withheld by SEBA. It is alleged in the FIR that the petitioner has illegally demanded money from the students and have caused serious damage to the academic career of the students, as well as cause mental harassment to the students and their family members. Learned counsel for the petitioner submits that the petitioner is not the authority which issues admit card. It is also submitted by learned counsel for the petitioner that the children of the informants had appeared in HSLC examination and the reasons for withholding of their results is known to SEBA only, but the informant did not approach the SEBA for redressal of their grievance. He further submits that the petitioner is ready to cooperate in the investigation. Learned counsel for the petitioner has also submitted that after filing of the FIR, the petitioner was called by which police called you?
Tarabari Police Station. Tarabari Police Station.
Called by the police of Tarabari Police Station, and on 26
June
26 June
and
and
27 June.
on 27 June. And on both occasions, the petitioner had appeared before the police and has cooperated with it. Stop. However, he submits that on 6th of July, the police registered the instant case against the petitioner under non-bailable provisions of law, and therefore he is apprehending his arrest. He submits that since the petitioner has already cooperated in the inquiry prior to registration of the case, he is ready to cooperate in the investigation. Hence, he may be allowed to go on bail. On the other hand, case diary would be required. On the other hand, learned additional public prosecutor has prayed for calling of the case diary. Call for the case diary. Let this matter be listed again on 11th of August. So in the meanwhile, considering the submissions made by learned counsel for the petitioner as discussed in foregoing paragraph, as well as considering the fact that the petitioner appears to have cooperated in the inquiry prior to registration of the FIR against him, he is directed to appear before the investigating officer of Tarabari PS case number 27/2025 within a period of 7 days from the date of this order and cooperate in the investigation. Stop. If he does so within the stipulated period of time, in the event of his arrest in connection with the above noted case, he shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of arresting authority with following conditions 1 and 2. List accordingly.
Please, your lordship, my lord, last item, my lord, only for alteration of some orders, my lord. Already granted bail, some alteration. Let me take after motion being over, my lord. Yes, the list is very long today also, my lord.
Okay, let us see.
Right, that's.
Item 18.
Nothing.
Your lordship.
Yes.
Okay, this present case is 482 anticipatory bail application. The petitioner is apprehending arrest. In respect of a proclamation and attachment order has been issued against him. In respect of a CR case pending in JMFC Golaghat, your lordship. The apprehension order is at page number 17, your lordship.
No, you approach before the trial court, make prayer before the trial court
The next
against the order of the court, whether anticipatory bail can be granted.
now police is approaching at his house each and every day, your
You
lordship.
approach the court which issued the.
The next date fix is 31/7, your lordship. Till then, your lordship, some kind of protection may be granted to him. He will certainly appear, your lordship. He has appeared. Last order for an till the next date, your lordship.
No. Okay. Heard Mr. Putul. Yes, thank you. Heard Mr. A.N. Iqbal, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioner who is apprehending arrest as the Court of Learned Judicial Magistrate, first class, has issued non-bailable warrant of arrest as well as, where is that order?
Lordship, page number 16.
As well as proclamation of the petitioner as an offender and orders for attachment of his properties. Stop. Without going into detail about the facts of the case, since as the orders of non-bailable warrant of arrest are issued by the by virtue of judicial order of the trial court, as well as the orders for proclaiming the petitioner as absconder, as well as attachment of his property, are also issued in judicial capacity unless said orders are challenged. The relief of anticipatory bail may not be granted in such cases. Hence, the petitioner is there when the date is fixed.
31/7.
Hence, this bail application is disposed of with a direction to the petitioner to appear before the trial court on the date, next date fixed before the trial court. That is on 31/7/2025. On appearing before the trial court, the petitioner may seek appropriate relief before such court. You appear before the trial court. This anticipatory bail, no, before this trial court, stop, finish. No further relief.
Your lordship, till his appearance, he may be granted some, no coercive action may be taken.
You should have come under 528.
Yes.
However, though this application has been filed under section 482 of BNSS, however, in exercise of inherent power of this court, the non-bailable warrant of arrest issued against the petitioner shall not be executed till the next date. That is on 31/7/2025.
Item 19.
Yes.
May I please, Your Lordship? Lordship, the allegation in the FIR is basically seizing of contraband substances from a vehicle wherein the petitioner is the registered owner. But basically,
the petitioner has transferred and handed over the vehicle just prior to the incident, my lord, because the incident had happened on 14/2/2024, and
Case diary would be required.
my lord,
Case diary would be required.
my lord. In this case, basically, if your lordship ever look at the agreement, my lord, at page 24,
No, let us see the case diary.
my
Heard Mr. B.M. Dekar, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. Let the case diary be called for. When?
Sri Bhumi, my lord, 6th of August.
Let this case be listed on 6th of August. 6th of August.
much obliged, my lord.
Item 20.
May it please the lordship. My lord, this is a anticipatory bail application, my lord. There are two petitioners before your lordship, my lord. My lord will find the FIR at page 13, my lord. Allegations are primarily against one Surjo Borua, the district social welfare officer, my lord, and we were his staff. Both these petitioners, one is UDA cum accountant, and another one is, LDA cum typist. Page 13 is the family.
What is the allegation?
Allegation is, my lord, Surjo Borua, with the help of these two petitioners, it is alleged that he misappropriated money under government schemes, my lord.
What is your case?
My case is this, Your Honor. Your Honor, we as, Your Honor, with all respected holiness, we as UDA or LDA assistant, we are not related to any other, my lord, directly involved in the misappropriation of money. My lord will kindly see the allegation. 3rd number para, Your Honor, my lord. That, sir, the details of corruption and illegal activities done by Surjo Borua in social welfare as given below. While
Which page? 13?
13, my lord.
Para?
3rd para, my lord. That, sir.
Yes, yes.
While Surjo Borua was IC SD, WO, Dhubri and IC CDPO 7 years, 7 different ICDS projects like so and so, so and so, so and so, so and so, used to collect illegal gratification and made corruption by engaging Soyed Noimul Haq. He is petitioner number 2. That is the allegation against him. And second one, my lord, while Surjo Borua was IC CDPO of so and so, also used to collect illegal gratification and make corruption by engaging Torun Mitra, LDA cum typist.
So you were a
My lord.
accomplice,
No, no,
co-accused.
it is the allegation. My lord,
Yes.
will kindly see page 17. Now, after lodging of this FIR, my lord, these notices were issued against both the petitioners under 35(3) and scheduled date is on 24/7. We are ready to cooperate. We will definitely appear, my lord. Kindly protect us because they are government employees. And case was registered in the month of April. And now notice has been issued against us to appear before the investigating agency.
Yes, Mr.
So kindly protect us till the return
Yes.
statement.
There is no apprehension, my lord. If the notice are issued, which one of custody doesn't arise.
It's 35(3) notice. Purpose is that there is no default.
Fine.
Yes,
But
that is there 24/7, my lord.
We will appear, my lord. We will cooperate whatever is necessary, my lord. We will disclose before the.
no, why are you apprehending?
Because of our names appear in the FIR, my lord, as accomplices. My lord, kindly see the paragraphs.
Well, considering the natural legal, that's why they have called upon
That is true, my
to
lord.
join the investigation.
That is why we are ready to cooperate because we are government employees, my lord.
So where is the apprehension?
Highly protected. Till the returnable date, if there is nothing, then we will withdraw our application. And if there is.
Case is a very initial stage, nothing has come up now. So only,
No, no, it is in the registered in the month of April, my
Maybe.
lord. Lordship will kindly see. And this Surjo Borua, he was arrested in connection with another case. In that case, we are not the accused persons.
and that is a disproportionate case. Disproportionate.
But in this case, there are clear accusation against you.
That is why, that is the apprehension, no? Because 41A and 35(3) similar, no?
Because if it is less than 7 years, my lord, the police, the investigating officer can issue notice, my lord, under subsection 3. of section
Yes, the purpose of 35(3) is that arrest is not required.
necessary.
My lord,
Therefore,
my lord.
then where is the apprehension?
Because our names are to the effect.
There
of
is
the-
no default. There is no default. Date is still
My lord,
with, so there is no apprehension.
No apprehension.
Otherwise,
my lord, that submission made by my senior friend, that might be, my lord, reflected in the order. That as notice has been issued under 35(3).
If you cooperate, if it doesn't appear, then matter is different.
yes, you have
No, we are ready to appear.
So if you
We
ready,
will
then
definitely
there is no
appear.
apprehension.
heard Mr. N.J. Datta, learned counsel for the petitioner.
And the Das.
Sorry, N.J. Das, learned counsel. A person to whom 35(3) notice has been issued, a person to whom 35(3) notice has been issued, when he can be arrested?
If when a person complies and continues to comply with a notice, he shall not be arrested.
He can be arrested. my lord.
Unless reasons to be recorded, police officer opinion, he ought to be arrested.
There
And
is-
that too, when person fails to comply, unwilling to identify himself, the police officer subject to such
Where are you reading?
subsection 5, my lord.
But it is under 3, man.
Okay.
35(3), man. My only apprehension is that we are government employees, we are daily doing our office. My lord, we are ready to cooperate. Kindly protect till the returnable date, my lord. That is my humble submission. Because allegations are also there, in which product, what amount of money misappropriated. The reason behind, my lord, if I go in detail, for our implication, lordship may kindly turn to, with all respect. Page,
So suppose, Mr. Kotoki,
Yes, ma'am.
suppose 35(3) notice has been issued.
Yes, ma'am.
He appears
Yes, ma'am.
and he answers your all queries.
Then he will have to go, he will be allowed to go, my lord. Question no, detention done, isn't it? Again, now we don't know what statement he will give. But mostly it appears, my lord, some transactions were there, bank transactions. So they will go for a bank transaction, whether that,
Police in such cases may even arrest,
generally they do not arrest. If he cooperates, question of arrest doesn't arise.
but power is there by giving reasons.
But then they have to take approval from the higher officer. Otherwise they cannot,
taking of higher approval, my lord,
that only they can do it because since it is below 7 years, so
Okay.
no, no, it is not below 7 years, lordship will kindly see.
no, in case, 35(3) notice. will be.
Kindly protect us till the returnable date, because we are government employees, my lord. Because and approval, taking of approval, my lord, from higher ups, even if we appear, we will not be able to know if they have taken approval or they have not taken approval. How can these persons know?
For that case, diary would be required.
Then in that case, they let him appear on 24th, my lord. So, and I don't think so they will be arrested.
Okay.
We will appear.
No, we are, I am recording the submissions made by Learned.
Yes, fine.
N.J. Das, learned counsel for the petitioner. Also heard Mr. P. Kotoki, learned special public prosecutor, CM Vigilance Cell. This application under section 482 of PNSS 2023 has been filed by the petitioners, namely Tarun Chandra Mitra, as well as
You'll also kindly see the notice also. They have laid down what he has to see, my lord. Great. In the notice itself, it's very clear.
Mr. Syed Noimul Haq, who are apprehending their arrest in connection with Vigilance PS case number 14/2024 under section 61 within bracket 2/318 within bracket 4, 316 within bracket 2, 316 within bracket 5 of BNS, read with section 13 within bracket 1 within bracket small a slash 13 within bracket 2 and 12 of the Prevention of Corruption Act. The acquisition, the gist of acquisition in this case is that on 17/4/2025, one Simul Sarkar had lodged an Simul Sarkar and 5 others had lodged an FIR before the Office Superintendent of Police, CM Special Vigilance Cell, inter alia alleging that one Surya Borwa, who was the in charge of DCWO Dhubri, had indulged in collecting, had indulged in corruption and had collected illegal gratification with help of the present petitioners. Stop. Learned counsel for the petitioner submits that the petitioner number 1 is the typist, LDA cum typist, as well as petitioner number 2 is the UDA assistant cum accountant in the District Social Welfare Department, Dhubri. And they have been issued notice under section 35(3) of BNSS and are directed to appear before the investigating officer on
24 and 25.
24/7/2025 and 25/7/2025 respectively. Petitioner, learned counsel for the petitioner has submitted that the petitioners are ready to cooperate in the investigation. However, since non-bailable provisions of law are involved in this case, they are apprehending that on their appearance, they may be arrested by the investigating officer. On the other hand, learned Special Public Prosecutor CM Vigilance Cell submitted that the purpose of issuance of notice under section 35(3) of BNSS is that the investigating officer agency do not intend to arrest the petitioners if they cooperate in the investigation. He submits that the date of appearance before the investigating officer is 24/7/2025, has not yet lapsed, and if the petitioners complies with the notice, there is no question of arresting them in view of the provisions contained in section 35 within bracket 5 of the BNSS. 5 and 6 of BNSS. Stop. In view of submissions made by learned counsel for the learned Special Public Prosecutor, this court is also of the view that at present, since the date of appearance before the investigating officer has not yet lapsed, and the petitioner can very well appear before the investigating officer on the said date and comply with the notice. Hence, at this stage, there is no apprehension of their getting arrested in connection with the above mentioned case. Accordingly, this anticipatory bail application is disposed of with directions to both the petitioner to appear before the investigating officer in compliance with the notice under section 35(3) on the date fixed in those notices. On the dates fixed in those notices. This Anticipated bail application is accordingly disposed.
Problem.
Hardy from supplementary list.
But this matter may be also be taken along with those series matter, this is tag matter.
Okay. It is related.
Yes, yes, same case, PID case, same.
Okay. Okay, we'll take up together.
Item fixed as last motion item, item 3.
Yes.
Here also FIR Lordship will find, it starts from page 9, relevant portion Lordship will find page 12. That one person who was running a hotel, he was arrested along with some meat, not a beef meat. And subsequently, on the basis of his statement, also the present petitioner was arrested. That your lordship will find the forwarding report, page 15. First ground, your lordship will see page 15.
Why your prayer was rejected?
His prayer was not rejected, lordship. That
You have not filed any application. Then case diary would be required.
lordship, the forwarding report, police custody was not sought. Lordship, in the first paragraph.
No.
Police was not.
In first paragraph,
Yes.
grounds of arrest.
No, in the first, sir, after the reference case number, with reference to the subject cited above, I have the honor to report that I am forwarding here with below noted accused person who has been arrested in connection with the above reference case. I pray before your honorable court to remand him in judicial custody for a stipulated period of time to enable me to complete the investigation of the case. So police remand was not sought.
Why you were arrested?
Because lordship, ground number 1, your lordship will find that the arrested person says that I am also selling raw beef meat, but he has not said that he purchased from me. And nothing was recovered from my possession, lordship. And if your lordship see the ground number 3, this says that I have produced one license saying that I used to sell buffalo meat in the name of lordship, beef meat. Now, my case is that, lordship, I am having a shop. That license, your lordship will find page 17, trade license. I am running a goat meat shop, lordship. No buffalo. That license was produced to them. They have not perused it properly, lordship. Therefore, they have written that in the name of buffalo meat license, I am running a goat meat. Page 17, lordship, may kindly see for a moment.
What is the affair?
FIR, lordship, against the hotel owner, from him it was recovered. They are in the
With that recovery, how are you linked?
I am not connected. In the forwarding report also, I do not find anything except the allegation that I am also selling beef meat.
Accused petition, ground number 1, ground of arrest number, during the investigation, which is the incident case previously arrested, accused person Wazidur Rahman. Currently in judicial custody was examined, and during his statement record, it was learned that the above below named accused person has been selling raw beef meat since long time and have been operating this business in a bulk quantity. So, he, Paras, maybe he is a goat license and.
No. Acquisition is,
Yes.
FIR is
FIR,
in respect of a specific offense where how much, what was recovered?
From him 6 kg cooked meat and 6 kg
Hotel them.
From whom?
the hotel owner.
From hotel owner, 6 kg cooked meat. That is the acquisition.
Hotel by themselves, slaughter, it may be supply from somewhere. During the investigation, it may come, so it can be revealed only from the city.
No, it is the allegation against hotel owner, he slaughtered. In the FIR itself, page 12, lordship, may kindly see second paragraph. Beef product and incubating materials were seized from the mentioned hotel. The hotel establishment do not possess.
No, in the grounds of arrest itself, it is clear that he used to sell, but whether the meat which was recovered is connected.
Yeah, It could have been a separate
No, but just CD, my lord. It is not in details.
No. The forwarding report should disclose. What is your submission, Mr. Parashar?
But this is, my lord, yes, that is not clearly given that from who, but
The grounds of arrest itself does not justify.
But the co-accused person who was already in custody, he stated that he's selling in bulk quantity. This distribution. And this is giving the investigation money.
There ought to have been a separate FIR in
Yes.
regarding that.
My lord,
He may be arrested, but in respect of an offense, different offense, but not this offense. Heard Mr. A. Ahmed, learned counsel for the petitioner. Also heard Mr. K. K. Parashar, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely Raful Ali alias Dudul, who has been arrested in connection with Satgaon PS case number 123/2025 under section 325/299 of BNS, read with section 11 within bracket 1 within bracket small Roman 1 of Prevention of Cruelty to Animals Act, read with section 13 within bracket 1 Roman 1/16 of Assam Cattle Preservation Act 2020. The gist of accusation in this case is that on on 1/7, which date FIR was on 1/7/2025. Nikhil Ranjan Neog, SI of police had lodged an FIR before the officer in charge of Satgaon police station, inter alia, alleging that on receipt of an information through on receipt of an information through credible sources and regarding illegal slaughter and sale of beef products, a raid was conducted. And during the raid, the hotel of one Wazidur Rahman was searched, and during search operation, where is the seizure? Where is the
In the FIR, it is not mentioned, but I have the certified copy of the seizure list. Also.
during search, raw beef meat was recovered therefrom. Learned counsel for the petitioner has submitted that the petitioner is in no way connected with the offense which has been alleged in the FIR. He submits that FIR relates to recovery of raw beef meat amounting to 6.6 kg, 6.8 kg, and cooked beef meat of 6 kg from which hotel?
Asiana Hotel.
From Asiana Hotel,
Situated at Noah Park.
whose owner is the named accused, namely Wazidur Rahman. He submits that there is no accusation regarding the beef meat against the petitioner regarding the beef meat which has been recovered from Asiana Hotel. He has learned counsel for the petitioner has submitted that the petitioner has been arrested only on the basis of the statement of Wazidur Rahman that the present petitioner is also has also been indulging in selling raw beef meat in bulk quantity. Stop. Learned counsel for the petitioner has submitted that no recovery has been made from the no recovery of any beef meat has been made from the petitioner, and even from the grounds of arrest shown in the forwarding report of the petitioner, which was submitted before the learned Chief Judicial Magistrate, Kamrup Metro, it appears that though there is accusation made against the petitioner of having involved in selling of beef meat, however, there is no link with the meat or beef meat recovered in connection with the FIR which has been lodged in this case. Learned counsel for the petitioner has submitted that the petitioner is ready to cooperate in the investigation. On the other hand, learned additional public prosecutor has submitted that as there is clear accusation against the petitioner of involving selling bulk quantity of meat, beef meat, he may not be granted bail at this stage without perusal of the case diary. Stop. On perusal of the Annexure 2, that is, I have considered the submissions made by learned counsel for both the sides. On perusal of the Annexure 2, that is, forwarding report of the investigating officer while forwarding the present petitioner after his arrest to the learned Chief Judicial Magistrate, Kamrup Metro, it appears that there is no indication as to how the present petitioner is connected with the acquisition made in FIR dated FIR which has been lodged in connection with this case. There is no indication as to whether any separate FIR has been lodged as regards accusation against the present petitioner that he has also been indulging in selling of large quantity of bulk quantity of beef meat. Stop. As the FIR lodged in the above noted case on 1/7/2025 relates to a specific offense on a specific date, specific offense regarding a specific instance, unless the accusation made against the present petitioner can be linked with the said offense, he may not be detained behind the bars merely on acquisition which is not linked with the with those acquisition which has been made in the FIR. Stop. In view of above, this court is of considered opinion that if the petitioner cooperates in the investigation, his custodial detention in connection with Satgaon PS case number 123/2025 may not be justified. Accordingly, he is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the learned Chief Judicial Magistrate, Kamrup Metro, with following conditions, number 1 and number 2. This bail application is accordingly disposed of.
Obliged, Lordship.
Finding item E.
As per my information and my lord, the order of the production dated, your lordship. On the said date, your lordship, the free legal aid advocate was represented me. So thereafter, no any bail petition was made.
Then case diary would be required.
Small quantity, your lordship, only 24 days already behind the bar, your lordship. I am a lady, your lordship. And the suspected heroin with container recovered from my backside of the house, your lordship, not from my position.
Total recovery is?
1.4.
Yes, Mr. Parashar. It is a small quantity.
Very small quantity.
It is bailable offense.
Yes, 54 days.
Heard.
Yes, Islam.
Heard Mr. S. Islam, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned counsel, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely Rukia Begum alias Rukia Begum, who has been detained behind the bars in connection with Mokalmua PS case number 161/2025 under section 21B/29 of the NDPS Act. Stop. The gist of accusation in this case is that on the basis of an FIR lodged on 26/6/2025. No. Where is the FIR?
So page number 14, your lords. 1.
25/6/2025. A search operation was conducted in the house of one Alauddin Ahmed and
Alauddin Ahmed is my husband.
Alauddin Ahmed, and during such operation, suspected brown sugar weighing about 20.27 grams within bracket with containers was recovered therefrom. And the present petitioner, who is the wife of the Alauddin Ahmed, was apprehended. Learned counsel for the petitioner has submitted that the petitioner is in no way involved in the offence alleged in the FIR. He submits that the said contraband, which excluding the container weighs only about 1.442 grams, was recovered from the backside of the house of the present petitioner. He further submits that the quantity of contraband recovered in this case is a small quantity, and thus this case ought to have been registered under section 21A of the NDPS Act, in which case the offence would have become bailable. Learned counsel for, I have also heard learned additional public prosecutor, who also submits that the quantity of contraband seized in this case is 1.42 grams. Stop. Considering the quantity of contraband seized as well as period of detention undergone, further custodial interrogation, further custodial detention of the petitioner is not required in this case for fair completion of the investigation in Mokolma PS case number 161/2025. Otherwise also, the facts reveals that this case ought to have been registered under section 21A of the NDPS Act, and the offence is as such is a bailable offence. Accordingly, the above named petitioner is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the learned special judge.
My lord, is Nalbari.
Special Judge Nalbari. CD is there. Learned Special Judge Nalbari. Subject to following conditions, number 1 and 2. This bail application is accordingly disposed of.
Master, please.
Period item 52.
Okay, your lordship, my lord, I was granted bail, my lord, and was directed to appear before the IO of the Umbranchu PS, my lord, case number 1 of 22, my lord. I appeared there, my lord, but then I come to know that the matter is shifted to CBI, but now the report has come, my lord, as per Lord's order last occasion. There is shift, the case is transferred to CID, no? CID, my lord, so I may be allowed to appear there in the new IO with some date, my lord.
Lordship, the facts are not that simple, Lordship. Lordship, the anticipatory bail was granted on 11/4/25, and he was directed to appear before the IO within 15 days. Lordship, why has he not appeared within the stipulated time, Lordship, before the IO? And the statements that he has made, that he was informed by the IO that the case has been transferred to CID, what prevented him from appearing before the CID, Lordship, within the stipulated time? He has to confidential, Lordship. He has violated the bail condition, Lordship. The explanation which he has given, Lordship, does not primarily satisfy, Lordship, that he was stopped by due reason, Lordship, for not appearing before the IO.
My lord, I appear within time, my lord.
No, he did not appear, Lordship. And he has made some very vague statement, very untrue statement, Lordship. The IO has stated that he never appeared before the IO.
My lord, I have detailed, my lord, with name and date and time, my lord, kindly see in paragraph 6, my lord.
Yeah,
120.
IO has informed you.
Yes, Lordship, I have received the report, Lordship. The objection I have received, Lordship.
Kindly have a look, paragraph.
Lordship, kindly go to the statements which he has made in the
Yes, my
IL.
lord. Yes, my lord. Paragraph 6, my lord, kindly have a look.
Lordship will kindly note that he was granted interim protection, AB Lordship, on 11/4/25. And he has preferred this instant bail application on 16/6/25.
My lord, kindly see, my lord, paragraph 6, my lord. There being the bifurcation on 12/4/24, the applicant obtains certificate copy of the order, appeared before the Umrangchu police on 24/4, my lord, and produced the same to before the OC of the police station. The OC then said the applicant that the original IO of the case, SI Viju Boro, is transferred, and asked the applicant to meet the second OC of the police station, who is the present IO of the case. Accordingly, the applicant met the second OC, namely SI Bikram Ingti, and submitted the copy of this order. After perusal of the order, the second OC of the case told the applicant as to why the applicant is implicating himself voluntarily in the case by filing the bail application and obtaining the order of the PRS bail, as he is neither named in the FIR nor in any way connected with the case. Then he asked the bail applicant to make a photocopy of the order and give it to him, which the applicant has done accordingly. Then the second OC said the case is transferred to CBI, and the office of which is at Guwahati, and that the applicant may or may not go there. And if the bail applicant wants to go also,
but he failed to give any proper address to the CBI official or the officer to whom to meet. Then the applicant also again went to the police station on 25/4, but no correct address or details of the case or the IO of the case could be traced out by the applicant. Then the applicant talked with the matter over telephone with the original IO of
Whether
the
case diary is there?
No, not possible.
Hello,
Earlier, without, this is interim bail.
Yes,
my lord, absolute, my lord.
without prejudicial power.
My lord, it is absolute was granted, my lord.
Lordship will kindly note that the bail was granted on 11/4/25. After that, Lordship, he has filed this
My lord,
present
my lord,
application.
if my-
Let me submit, please. This present IA has been filed on 6/6/25, Lordship. Lordship, what was he doing for 45 days or more, Lordship? What prevented him from appearing before the IO or the CID, Lordship? That has to be clearly, he has to justify that, Lordship.
Well,
He cannot just come and blame the IO of different IO, Lordship. He was informed by the IO, he could not, he does not know the office of the CID. What kind of statements are these, Lordship? There has
Okay.
to be some
Heard this
justification.
interlocutor. Heard Mr. A.K. Talukdar, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This interlocutory application has been filed in connection with AB case number 889/2025.
my lord, it was Umrangsu case number, my lord, earlier.
AB case number 889/2025, which was disposed of, whereby the anticipatory bail was granted to the petitioner in connection with Umrangsu PS case number 2 of 2025. Stop. Learned counsel for the petitioner has submitted that after grant of interim bail, the petitioner approached before the investigating officer of Umrangsu PS case number 2 of 2025. However, he was informed that the case has been transferred to CID.
My lord, I am told CBI, my lord, maybe I am wrong, my lord, because I am, my lord.
You have not mentioned.
My lord, yes, they told me CBI, but.
When,
AID, my lord.
you have not stated.
I have stated at CBI because, my lord, maybe, my lord, the petitioner is maybe wrong because he's a thumb impression, my lord, illiterate man, perhaps couldn't understand the name.
Transferred to CBI. Stop. And hence, he could not appear before the new investigating officer. On the other hand, learned additional public prosecutor has submitted that the petitioner deliberately defaulted in not appearing before the investigating officer of the case after it was transferred to CID. He also submits that the case has not been transferred to CBI as stated by the petitioner, but to CID. And the new case number is?
Not
We'll call for the case diary. Thereafter,
My
we'll.
lord, if your lordship permits me, I can give the call details of.
No, we'll.
For telephones, I have talked with the officers, and also maybe my learned friend may bring the.
No, you do whatever you think right.
CCTV footage, my lord, whether I have appeared or not, on that date.
You can do whatever you think right
My
for
learned
your
friend can
case.
to his custody, my lord. The CCTV footage on that day I have appeared before the IO, my lord, so, or to the OC, my lord.
Yeah, last night. What is the new case number?
Lordship, I don't have that number, Lordship. I will get it, Lordship.
So, new case number card diyo.
My lord, kindly see that till date, no number is there, my lord.
Therefore, why you need?
He's illiterate person, my lord. Maybe CBI, CID is.
Why you need protection?
My lord. I have to, your lordship has ordered me to appear, my lord. I have to appear somewhere, my lord. This IO or IO, my lord.
I'm changing that.
Only for that, my lord. I may be getting order to direct to appear before the present IO, my lord. That's only that.
I am very much my compliant.
Have you completed your submission?
My lord.
The perusal of the case diary would be necessary for considering the present interlocutory application. Hence, call for the case diary of Omrangshu PS case number 2/2024. It has been, after transfer, new case number has been
I will take care of it.
2/24.
We'll take care of it.
Stop. The learned additional public prosecutor assures to produce the case diary before this court on
Leave it to your lordship. Whatever they say.
on 31st of July. The interim order granted to the
That already lapsed, lordship, because
The
he was
protection granted to me.
directed to appear within 15 days. lordship.
that we will consider. The protection granted to the petitioner by order dated
11/4.
11/4/2024,
55, lordship.
2025, passed in AB case number 889 shall continue till next date. After receipt of the case diary, the question as to whether there has been any default on the part of the petitioner in complying with the conditions shall be considered.
Will hearing be item 21? It's a NDPS matter also.
Yes,
Already, lordship, the statutory period is over. Statutory period is already over, lordship. You cannot.
Today is 80 days. 80 days.
80.
80 days, lordship, and
What is the statutory period?
it is, lordship, under intermediate quantity, lordship.
Then why have you not approached before the trial court
Trial court, I have appeared, lordship.
after lapse of statutory period?
I have appeared before and by the trial court, I am annexing that order. My bail application was rejected on 5/6/25.
Yes, 5/6.
Then statutory period was not over.
Yes, then it was not over. Now it is over, lordship.
You should have gone before the trial court. And otherwise also during regular production, you will be released. Heard Mr.
G. Kakoti.
G. Kakoti, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application has been filed by the petitioner under section, petitioner Ali Hussain under section 483 of BNSS in respect of an offense with allegation of possessing how much?
Lordship, 18.36 grams.
Of 18.36 grams of suspected heroin. On the basis of such accusation, Panbazar PS case number 155/2025 under section 21B/29 of the NDPS was registered. Learned counsel for the petitioner submits that the petitioner was arrested on 1/5/2025 and today, as on date, he has completed 80 days behind the bars. He also submits that the maximum statutory period of detention for the offense alleged against the petitioner, is not is 60 days under section 487 of BNSS. Stop. Learned additional public prosecutor also submits that the maximum statutory period of detention under 487 of the BNSS is complete in this case, and the detention of the petitioner is beyond the period which has been prescribed under section 487 of BNSS. Stop. In view of above facts, the above named petitioner is allowed to go on bail of rupees 50,000 with one surety of like amount, subject to the satisfaction of Ekline Arudibo. Learned additional public prosecutor has also submitted that the investigation is still going on and charge sheet has not yet been laid. Stop. In view of above facts, the petitioner is allowed to go on bail of rupees 50,000 with one surety of like amount, subject to the satisfaction of learned Special Judge Kamrup Metro with following conditions. Number 1, number 2. This bail application is accordingly disposed of.
Item 22.
Lordship, CD has not been received.
May I please, Your Lordship? My lord, this is regular bail application, my lord. 60 days offense, my lord. I have completed 43 days, my lord. The FIR is at page number 10, my lord.
When can you produce? What is the offense?
My lord, offense is that the petitioner posted one video in Instagram account, my lord, threatening the majority community of the country, my lord. Since the mobile has been seized and the video is also.
When can you produce the case?
Next week, Lordship. 24 or 25.
Heard Mr. A. Parmanik, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who prays for some more time for producing the case diary. Prayer is allowed. Let this case be listed again on 24th of July.
45th.
25th of July.
Item
41 on supplementary list.
Your Lordship. Petitioner was arrested on 6/4/2022. Today is about 3 years, 3 months, 11 days. Also. And in this case, 2 persons were arrested. One is petitioner, another is Vishnu Singh. He was subsequently arrested and he got bail from the court below, Lordship. It is, Lordship will find this at page number 56, relevant portion at 57 also.
On what ground?
Lordship, by the trial court, time and again called IO, and there for his examination he has not appeared, and subsequently as from his position nothing recovered. Because of that reason, Lordship, the trial court itself on 4/10/2023, his bail was considered by the learned trial court, Lordship. It is reflected in the page number 57, last paragraph, Lordship.
Okay, now what is your case? Prolonged incarceration.
For prolonged incarceration. I was the driver of that truck and owners are different person, Lordship. It is reflected in the final complaint, Lordship. And in the final complaint, there are so many persons accused, 5 numbers.
What is the status of the trial?
9 witnesses cited in the final complaint. Out of 9, 5 witnesses examined, Lordship. 5, Lordship, chief part completed, cross part halfly done, Lordship. That could not be completed due to paucity of time that day. And
PW5.
PW5 seizing officer, Lordship. And out of 9, Lordship, 4 still yet to be examined, Lordship. In this case, Lordship, petitioner is inside the jail 3 years, 3 months.
How much was the contraband?
Contraband was 4601.78 kg of ganja, Lordship. 113 packets of ganja, Lordship.
Huge quantity.
Huge quantity. But he is the driver, my lord, the owner is still there absconding, lordship. It is reflected in the final complaint, lordship. Apuranjan in the lordship, lordship will find at page number 25. Apuranjan Das in page number 26, lordship, and Lokesh Sin and Laxman Singh who book all these things.
He has been declared as absconder.
These are showing as absconder in the final complaint.
Yes, Mr. Kyal.
Here, is correct, lordship, 5 witnesses has been examined, 5 is yet to be cross-examined by the prosecution, lordship. And the witness appeared before the court time, lordship, but he was not examined earlier. Lordship,
Court time?
yes. Court time.
I have collected the certified copy of the order sheet, lordship, last. It is
And
in
lordship,
the
here
record and
contravened is
thereafter.
4,601 kgs. It was recovered from the conscious position of the petitioner.
The co-accused who was granted bail,
He was recovered from him.
how he was involved,
Lordship,
co-driver or
So he was
he was
co-driver. Subsequently, what happened, he left the vehicle at that area. Then subsequently, he arrested in front of the Audi showroom here in the Guwahati. Because driver has revealed the name.
44 lordship is role.
okay, okay. Now against prolonged incarceration.
Lordship, in case of NDPS lordship, this cannot be considered as a prolonged incarceration. Earlier, well, some already submitted that earlier lordship, before Until's case, this 436 capital was not applicable in case of NDPS. On that judgment, it was then lordship, we considered that, then minimum, we have to consider the maximum punishment. Maximum punishment is 20 years. Lordship. And he was arrested on 6/4/2022. And out of 9 witnesses,
No, it didn't.
4 witnesses examined fully, 5 is yet to be cross-examined. And lordship, follows this document. Paragraph 11 of this submission.
Pollution is in different body. What to do?
Paragraph 11.
Para 11 with regard to parity.
Parity, lordship, and the conscious, when it contraband has been seized from the
Conscious
of the
possession.
petitioner, then he is not entitled to. And this Kasif judgment, lordship, paragraph 39.1 and 2. Purpose of act is to be seen before enlarging the accused on the road.
Next, kita tama yung
Okay. Okay, heard Ms. S.K. Nargis, learned counsel for the petitioner. Also heard Mr. S.C. Kyal, learned standing counsel NCB. Place this matter for delivery of orders on 29 July. 29 July.
Lordship, judgment is there, lordship, I would like to place that one.
Yeah.
Ida GGB, I'll place that.
29.
Item 42.
My lord, in this case, nothing recovered from my position, lordship. My implication was not in the final complaint filed by them, lordship. I have not made accused in the final complaint, lordship. Lordship will find final complaint at page number 21, lordship.
Page number?
21, lordship. I have not made accused in the final complaint,
What
lordship.
is your name?
My name is Achelal Sahani, lordship.
Achay Lal Sahani.
Sahani.
Okay.
I have not made accused in this case. Lordship subsequently, though they have mentioned in the final comment in last page, Lordship, there is some, if there will be find any incriminating material against me during investigation, they sought prayer before the court to file supplementary complaint before the court, Lordship. It is mentioned in the page number 59, lordship, in last paragraph. Then they have filed a supplementary complaint at page number 57, lordship.
Page number?
57. 57 is a supplementary complaint against me and one Lakhan Das. Then I was arrested in this case, lordship, on lordship 23/10/2021. Today is about 3 years, 8 months, 24 days. And in this case, supplementary charge sheet submitted. Supplementary charge sheet submitted on 8/4/2022. And lordship, in this case, final complaint submitted on 21/9/2021. Right now, in this case, 30 numbers of witnesses cited in the final complaint, lordship. Out of that, lordship, only 3 witnesses are examined till today, lordship. And there is allegation that I was involved in 3 another cases. Lordship, in a similar manner, they have alleged in the other final complaint also, lordship. This is mentioned in the supplementary complaint, lordship, and their objection. So, lordship, in this case, in that case, they in the objection they have stated that I was in contact with one Kisani. I was in Pappu Kumar. I was in contact with my mobile number 8099505411, through which I was in contact with one Pappu Kumar alias Pappu Kumar Sahani. But lordship, this person arrested in some other cases and he got bail from the from this honorable court. And in the final complaint, lordship,
No, in this case, how you are involved?
Because lordship, my name whispered by the some arrested person. First, lordship, initially arrested 2 persons, Pavin Kumar and Nanu Babu Mahato. They were arrested on 7/10/2021, and thereafter, lordship, Aksalal Gaurabbir Sahani and Aksalal Sahani then arrested, lordship. They stated and they identified my photographs, lordship. That is the statement, lordship. It is, lordship will find this allegation at page number 49. আর কোনে বেল বেশি বেল কত এই যে and their roll lordship 58. Here some other number mentioned in the supplementary charge sheet, they have stated some other number lordship as in contact with those person, with the owners and the arrested accused person and this person who got bail lordship with Pappu Sahani. Then lordship, in this case, one Ajay Kumar Singh, who is main accused in the final complaint lordship, he got bail lordship. Lordship will find at page number 89.
Yes.
In, and though there is allegation that in three more cases I was involved lordship, in similar manner lordship, somebody whispered my name and accordingly my name, they have shown arrested in those cases also. So my lord, I am inside the jail since the date of my arrest, that is lordship 23/10/2021. 3 years, 8 months, 24 days, lordship. In this regard, I would like to the order passed by this honorable court in regards to the accused or petitioner lordship Fazal Devna. Lordship passes. He was also involved in 3 cases. Lordship granted bail. He is appearing before the trial court right now.
Kajal Devnath, you are relying to
This-
show
For Achalal Sahani, lordship, in this petition.
for what purpose?
Lordship, he is also in, he is also, the allegation is similar. He is also arrested on the basis of the statement in the similar manner also. Huh? And in the all 3 cases, lordship. And nothing recovered from his position also, lordship. And he has placed in earlier case lordship Palod Lobby lordship. Palod Lobby is in our favor lordship. If nothing recovered on the basis of the statement 67 lordship.
Yes.
That's in my objection, page 106, paragraph 9, 10 and 11.
Then 11. When is it? Earlier 22 3
106, 107.
PDNDS complete.
Yes.
Paragraph 9. When the investigation is progress established that the accused person Rakhel Sani and other accused persons in the instant case were consciously involved in commissioning of the trafficking of ganja and presumption under section 35, 34 of the NDPSA as to be culpable mental state of the accused persons can be found. 10. That from the facts and circumstances established that accused person Rakhel Sani was arrested for his conscious involvement in illegal trafficking of 426.910 cases of ganja, which is much more than commercial quantity, and hence he is in violation of the provision of sanctions. In paragraph 11, the earlier bail petition of accused Acharal Sani in the Guwahati High Court by petition number so was rejected by the Honorable Guwahati High Court by the authority 25/11/2022. Another bail application filed earlier by accused Acharal Sani in the Guwahati High Court by petition number so was also rejected on 21/10/2024. 10. That on the basis of past criminal record of Acharal Sani, preventive detention under NDPS Act 1988 has been also imposed to accused so. On 29/12/2022, order was passed, then order was executed, and the 23/23 order was confirmed. Then also we have given the number of 4 cases where it was found to be involved. Is a visual offender also.
Yes.
Under the circumstances, he is not entitled to bail.
Heard, Miss.
My lord, in this case, I would like to place Attaur Rahman's case. In this case also, Pete NDPS was imposed, Lordship, for 1 year. Subsequently, division bench closed the matter. Your Lordship was present, was there, Lordship. That is why, Lordship, that was earlier rejected by dishonorable court. Subsequently, on last occasion, Lordship granted bail, Lordship. He was also earlier convicted, Lordship. That I would like to place before this court, Lordship. In this case also. My lord, one more thing is that, what my learned
In this
friend,
case, the preventive detention order was challenged
that was not challenged because that was 1 year and 1 year
as lapsed.
lapsed
Okay.
because of these cases. And my lord, what number in the objection he has mentioned, that is not related to this case, lordship. Some other case also rejected by this court, lordship. 3 more cases are there, that is why, lordship. I'll place that order also. That is rejected on 21/10/2024 in other case also.
Heard Ms. S.K. Nargis, learned counsel for the petitioner. Also heard Mr. S.C. Kyan, learned special public prosecutor. Public prosecutor, NCB. Let this case be listed for delivery of orders on 4th of August.
No, sorry. Obliged.
1943.
May I please your lordship? Lordship, this is a 483 paid application. The period of detention is 6 months, 10 days in custody.
What is the offense?
Your lordship, the gist of the matter is that NDPS commercial quantity. Gist of the matter is on 10th of September 2022, a truck was intercepted in a garage in National Highway number 37, Lalmati, Guwahati, your lordship. In the truck, there was a driver of the truck, and from his conscious possession, around 404 kilogram of cannabis was recovered, your honor. Your honor, I am the instant petitioner. I am not the driver of the truck. I am not the owner of the truck. There is only two specific allegation against me, which I would like to address, your honor. Your lordship.
Yes.
Your lordship, the specific allegation against me is that not with regards to the current owner of the truck, not with regards to the driver of the truck, but with regards to the previous owner of the truck. When the owner of this particular truck was purchasing the truck, I transferred an amount of rupees 2 lakhs to the previous owner's account. And that to 6 months prior to the date of occurrence of this particular, on which date the truck was intercepted. That is 6 months prior, not any connection with regards to the instant delivery or trade of narcotics, your honor. Your lordship, in the entire final report submitted by the Director of Revenue Intelligence, there is not even one single line in the entire final report which connects me to the trade of narcotics, your lordship. The only thing which connects me with the entire allegation is that, as per the statement of the driver from whose conscious possession the narcotics was recovered, is that I transferred him 15,000. That is my husband, not me. My husband transferred him 15,000.
Your lady.
I am the lady, your honor. My account was used. My bank account was used, and that is the only specific allegation against. There is no other allegation in the entire final report filed by the Director of Agri Intelligence. Your lordship, furthermore, your lordship, if your lordship may kindly come to page number 76, your lordship. 76 of our petition, your lordship. Here, your lordship, what happened? That the Directorate of Revenue Intelligence served as summons, but that summons were never delivered, and it is mentioned in the final report. Even thereafter, we were mentioned as absconder, which means we were never informed about the case, and then still we are called as absconder. Thereafter, when we appeared before the trial court, we were in judicial custody from 10th of January 2025, your lordship. Your lordship, page number 76, 76, last paragraph. Investigation also discovered that at the time of purchase.
Which para? Slow, be slow.
Page number 76, last paragraph.
Which para?
Last paragraph.
Page number 76.
Last paragraph.
Yes.
Investigation also discovered that at the time of purchasing of the said container truck, Shri Jhilik Ghosh, that is the petitioner, has transferred rupees 2 lakhs to one Shri Lavkesh Jalan, who is the previous owner, through online mode. His account number so.
You are Jhilik Ghosh.
I am Jhilik Ghosh. Through online mode to the account number so and so on 30/3/2022. That is 6 months prior to the recovery of the trucks, your lordship. As the Axis Bank account details, his address is showing Shri Jhilik Ghosh of Dattapukur, North West Bengal. On 14/2/2023, white letter number so and so, addressed to the Deputy Directorate of Revenue Intelligence, Kolkata Zonal Unit, suit number 1617, a particular address is mentioned, was sent from this office and requested to conduct follow-up inquiry at the address of Jhilik Ghosh. Dattapukur, Netaji Nagar, West Bengal. Reply still awaited from DRI Kolkata Zonal Unit. Even if the reply was awaited, I was mentioned as an absconder in the same final report, Your Lordship. And therefore, thereafter, Your Lordship, the person on whose behest I have transferred the amount, he is also in his, Your Lordship may kindly come to page number 55, Your Lordship. Your Lordship, page number 55, paragraph number 39, Your Lordship. May I read, Your Lordship?
Yes.
Your Honor, after scrutiny of the DTO Nagaland report in respect of the seized Tata container truck bearing registration number NL01AF7084, it is found that the said vehicle is registered in the name of one Sri Liton Malakar. A summon notice number this was issued to Sri Latan Malakar of Nagaland under section 67 of the NDPS Act 1985 to appear before the investigating officer on or before 6th of January 2023 at 11 hours at the office of the Additional Director General, Minor Tower, Tristan Bosti, GS Road. Accordingly, on 28th December 2022, the Postal Authority has returned the summon notice with remarks that insufficient address which was written on the body of the envelope, which means the owner of the truck also has not received the summon, and even thereafter he has been marked as an absconder, Your Lordship. Which means in both the situations, the owner of the truck on whose behest I has transferred the money, and to me, no notice were served, no summons were served, and even after that we are mentioned as absconder, Your Lordship. This is our point number 1, Your Lordship. And thereafter, when I came to know about this, Your Lordship, I preferred a criminal petition before this honorable court. Before this honorable court, Your Lordship, and the NBWs which were issued against me were recalled, and direction was given to me to appear before the district and session judge, Your Lordship. That is the trial court, Your Lordship. And thereafter, when I appeared before the trial court, Your Lordship, I was detained in custody, and my husband has already been discharged, Your Lordship, from the entire trial proceeding, Your Lordship. And the accused person, that is the driver of the truck, he's also been released on bail, Your Lordship.
Driver released on what ground?
Grounds of, Your Lordship, grounds of non-compliance of 52 and 47 of the BNS, that is grounds of arrest, Your Lordship. And also, Your Lordship, furthermore, I'd like just to submit one thing. May Your Lordship come to page number 82, Your Lordship. That is the final summary of the entire investigation done by the Directorate of Revenue Intelligence. Paragraph number 51 and 52 in page number 82, Your Lordship. Page number 82. This is the conclusion drawn by the investigating agency, Your Lordship. May I kindly read the...
Yes.
Paragraph number 51, Your Lordship. Your Honor, as discussed in the foregoing paragraph, it is evident that Sri Gopal Chandra Rai, the driver of the seized container truck bearing registration number NL01AF7084, has been found to be involved in possessing and transporting the contraband in a conscious state of mind, kept in a specially built secret chamber on the said container truck, and was transporting the same to the destination as directed by Litan Malakar and Sri Kajal Malakar, thereby contravened the provisions of Section 8C of the NDPS Act and committed an offence punishable under Section 20B2C, read with Section 25 and 29. Paragraph number 52, Your Honor, it further transpires that Sri Litan Malakar and Sri Kajal Malakar, the owner of the truck, have been found connected in acquiring, possessing, transporting the seized 2004 kilograms of ganja in contravention of the provisions of 8C of the NDPS Act, thereby rendering themselves liable for penalty under Section 20B2C, read with Section 25 and 29 of the said Act, Your Lordship. In the conclusion of the entire final report submitted by the Directorate of Revenue Intelligence, Your Lordship, there is no mention about it. Only one single line is mentioned that I have not complied with the summons. Whereas in the same report, it is stated that summons were never served to me, Your Lordship. This is my entire humble submission before the Honorable Court, Your Lordship.
In this case, we file objection. Let's say we come to page 123, paragraph 2.
$120.
Page 123, paragraph 2, 3, 4, 5, and 6.
123 page number is not there.
Page 123 is there, Lord. Probably it is there.
Yes, yes, it is there. 120.
Page 123, paragraph 2, 3, 4, 5, and 6.
How he is connected?
Lordship, please to see paragraph 3. It is stated that there are documentary evidence, bank transactions showing direct involvement of accused persons, namely Srimati Jilika Ghosh and Subrata Devnath in the drug trafficking racket gang. It is further stated the petitioner accused persons has close ties with the main accused and is directly involved in supporting or facilitating the offense by financing drug transaction and necessary arrangements for transport of the seized contraband. Further, as per the bank statement of Srimati Julika Ghosh, there are.
No,
huge-
just a minute before that. The 30, how much was transferred from your bank?
Your Lordship, there is no transaction to the driver or the owner. To the previous owner, 6 months prior, 2 lakh rupees was transferred, which was he's borrowed. This is the owner of the truck, Litan Malaka, not to the any accused person, Your Lordship.
And
on the date on which I transferred to another shop, that is not me, through my husband, and that at the behest of Litan Malakar, it was his truck, 15,000 rupees only, Your Lordship.
to whom?
To the to a shop near the garage where the car was parked for repairing and for the repairing work of the truck, Your Lordship, and not to the driver. And it is mentioned in the statement of the driver himself, Your Lordship, that he asked money for repairing the truck, Your Lordship.
So all the evidence has been placed before the trial court, and next date is fixed on 22/7/25 for coming charge against the present petitioner. 22nd.
No, it may be, but their plea is that
Their plea may be there, Lordship, but materials are before the trial court. That will be called for when the Lordship want to see. Because Lordship charges not been framed against this petitioner, because if
no, the scan copy has been
Received.
received.
then Lordship may peruse here. Because materials are there, and in objection, we have clearly stated that in paragraph 3, below part, further as per the bank statement of Srimati Julika Ghosh, there are huge unexplained financial transactions from various parts of Assam, which are clearly linked with drug-related earnings, and thus it is established that conspiracy or abatement under section 29 of NDPS Act. And while filing the complaint, they were found absconded also. The charge sheet was filed, and subsequently she approached the dishonorable court, directed her to appear before the trial court. Thereafter, Lordship, the case is fixed for on 22nd for framing charge against the present petitioner.
Your Lord.
You give a gist of your submissions
In
in a sheet.
Yes, sheet. Then
And your submission is that the transaction, bank transaction,
Yes.
that is in connection with some drug dealing would be revealed from the evidence.
From the bank statement of the petitioner.
No, bank statement will only show that from whose,
Yes, okay, that during investigation, it has been revealed like place before Lordship.
two things with regards to that, Your Lordship. In paragraph number 2 of the reply filed by the Directorate of Revenue Intelligence, Your Lordship, in this entire paragraph number 2, they have mentioned the memo number and date of all relevant documents, but they could not produce or mention the memo number or date or anything with regards to the service of notice to the current petitioner, Your Lordship. There is no mention. And in the final report, they are saying that reply is awaited. When reply is awaited, how come that person is mentioned as an absconder?
no, no, question is even if you are absconder or not absconder is not material. Whether 37 conditions are fulfilled or not. If it is, if you can overcome 37, only then you will get bail.
Indeed, Your Lordship.
Otherwise, not.
Indeed, Your Lordship. With regards to the transactions, Your Lordship, again, there is a vague allegation there are multiple transactions, not even one specific could be shown, Your Lordship. There is no specific transaction to show that we are connected to the drug trade, Your Lordship. 6 months prior, with regards to the purchase of a truck, there is a transaction which is in usual course of business, Your Lordship. And again, with regards to
Okay,
15,000
that you have
for
submitted.
the
You give a gist of your submission.
Indeed, Your Lordship. Written submission, Your Lordship.
Yes. Heard, Mr. What is your name?
Sorry, Your Lordship.
D. Laskar, Learned Counsel for the petitioner. Also heard Mr. SCKL, Learned Standing Counsel, DRI. Let this case be listed for. When is the date fixed in before the trial?
22nd
Of
July
July?
for
On
framing charge.
4th of August. 4th of August.
Your Lordship, any date on the last week of July also, Your Lordship. Before that, I will submit.
No, what is the difficulty on fourth?
Already 6 months behind the bar and she has two minor children, Your Lordship. She is a lady and she has two minor children. Your
No, the offense is of NDPS. If you cannot, if you are unable to overcome 37, then you will be there for longer period.
Your Lordship will go ahead with.
So I will have to verify. 4th of August.
Much obliged, Your Lordship.
You give a gist of
Indeed.
submission to the court master.
Indeed.
You can also give, indicating the evidence.
What we have submitted before the trial court for pending charge.
Much obliged.
Within 2 days, 2 or 3 days,
By Tuesday, I'll.
by Tuesday. Okay.
Much obliged.
Delivery of.
Item 44.
Yes. Yes.
Yes. In the regular bail application,
Item 34. Yes. What is your submission?
it is 61 days in fact.
How many days? Be louder.
61 days.
61. What is your submission? What is this? He has completed the statutory period. Okay, okay. What is the contraband?
Heroin,
How much?
12.60 grams.
Heard, Mr. What is your name? M. Rahman, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who submits that in this case, the case diary has been received, which reveals that the petitioner, namely Akash Ali alias Nadu, who was arrested in connection with Howli PS case number 27/25 on 25/2025, has completed 61 days of detention behind the bars. Stop. Learned counsel for the petitioner has submitted that the quantity of contraband, that is heroin, suspected heroin seized in this case is 12.60 grams, which is a intermediate quantity, and therefore the statutory period of detention for which the petitioner may be detained behind the bar under section 487 of BNSS is only 60 days, which he has already completed. So, in view of the submissions made by learned counsel for both the sides, as well as the petitioner has completed the statutory period of detention, he is allowed to go on bail of rupees 50,000 with one surety of like amount, subject to the satisfaction of the learned Special Judge Borpeta. Special Judge Borpeta, with following conditions, NDPS conditions. This bail application is accordingly disposed of.
Item 45.
Please, your lordship. Lordship, in this case also petitioner was arrested on the basis of the statement on 15/3/2022. In this case, lordship granted bail to the main accused Krishna Muhammad Ali on lordship 15/7/2025. For long incarceration, Lordship, I would like to place that one, Lordship. From my position, nothing recovered, Lordship. Yeah, I'm inside the jail for about 3 years, 4 months, 2 days. On the basis of the statement of one Tyagi Ranjan, you person, Tyagi Ranjan. Tyagi Ranjan also got bail, Lordship.
Yes.
See my objection page 100, paragraph 20, 24 and 25.
20.
As paragraph 20, page 100.
Yes.
Paragraph 20.
Yes.
The prosecution witness have been appearing continuously before the honorable court, but defense counsel are not examining them. Most of the time, defense counsel pray for adjournment for different reasons, and most of the time, they do not represent the accused. This is the main reason for due to there is unnecessary delay in trial. On last date, 3/5/25, prosecution witness namely Shakil Ahmed was appeared before the honorable court, but he was not cross-examined as a learned counsel for the accused Ramesh G was not appeared before the court and prayed for adjournment by filing petition due to the said reason. Only 2 witnesses could be examined in this case. Then paragraph 24.
How many witnesses are there?
15 witnesses, Lordship. 2 witnesses only examined.
Then paragraph 24. That the final complaint, charge sheet of this case has been filed within the stipulated time. A supplementary complaint was also filed against Mariappan M. In this case, if the bail granted, there is a possibility that the accused may jump the bail considering the gravity of the offense and severity of the punishment prescribed under NDPS Act. He may get himself involved in similar nature of offense as remain habitual offender. Then paragraph 25, next page. That Mariappan M is an habitual offender and he has been was also arrested in connection with seizure of 8.211 kg of crystal methamphetamine seized by NCB Chennai Zone Unit 5 NCB Chennai crime number 9 of 2021, crime number so and so.
How long you are behind the bars?
I'm behind the bar for about 3 years, 4 months, 2 days, Lordship.
Miss SK.
Yesterday, in one of our case, Apex for the passed the order, Lordship. Kindly see the paragraph number 5, last 3, 4 lines, Lordship.
What is it?
There is no clinching evidence or that has been specifically mentioned.
In
Lordship.
this case?
No, in that case, Lordship, I would like to refer in this case, Lordship. It is in some other case, Lordship.
In some other case, clinching evidence is not there.
That not there and
How it will help you in this case?
long incarceration also considered, Lordship.
Yes, that you may say.
In our case also, there is no clinching evidence, Lordship.
No, that you have not argued.
Long incarceration also considered there, Lordship.
Okay. Heard Ms. SK Nargis, learned counsel for the petitioner. Also heard Mr. SCKL, learned additional public prosecutor. It will take time for dictation. Monday.
Monday probably Lordship
Tuesday. Heard Mr. SCKL, learned additional public prosecutor. Let this case be listed for delivery of orders on Tuesday. That is 22nd July.
Obliged, Lordship.
delivery of orders.
Item 36. Please, your lordship. My lord, the first FIR is related to section 4 of the POSCO Act, where there are 3 accused. And all the 3 accused were released on bail, my lord, after period of the statutory period, my lord. Now, in respect of the present petitioner, he is the father of the accused number 3.
Accused number?
Accused number 1, my lord, accused number 1. Now, subsequent FIR was lodged on 22/5/2025, my lord. What happened, my lord? Page 23, if you are translated copy. He the
No, whether the informant has appeared. This is a POXO case.
Yes.
Oh, you are appearing. Okay.
My lord, this.
Where is the FIR against you?
Page 23. In respect of section 241, destruction of document, and section 324, mischief, nothing else. And the police already submitted the charge sheet. Charge sheet is with the scan copy. Charge sheet already received before this honorable court, my lord. I have also the scan copy. Certified scan copy.
When were you arrested?
My lord, 22, I was arrested. 22/6, I was.
For the informant. This application under section 483 of BNSS has been filed by the petitioner, namely.
Very young boy, my lord. All co-accused were released. 58 days is offered today in jail. My lord, May on Tuesday, my lord, 22/7.
Okay.
22/7, my lord.
58 to Tuesday.
I think 37, your lordship, mandatory is over, your lordship. One day before it was listed, your lordship, but not this.
Item number?
37.
How long you are behind the bars?
90 days, now custody 103 days.
Okay, 37 record to bhitor debo. I'll go through. If mandatory period is over, yes, anything? Yes, Mr. Parasharan Sharma.
It's the only last occasion, lordship, that big one, lordship.
Oh.
Big, Mr. Lordship, serious case, Your Lordship, we are waiting.
No, 37.
That big one, lordship.
37 was, it
Yes.
has to be gone.
Yes.
It has to be looked into. Yes, yesterday it was also fixed.
Again, please today.
Again on Tuesday.
3 days, your lordship. And
No, is it a serious case?
no, item 30.
This is not a serious case.
Serious case. No, it's not a serious case, lordship, it's an individual.
Yes. You have gone through the case diary.
Yes, lordship, here, lordship, UAP Act 90 days is over, lordship, and extension has not been sought.
Okay. If it is so, then you will be granted bail. I'll verify.
Obligation.
The order city, lordship.
Okay. I'll pass orders in the chambers.
Yes.
Obligation.
Yes.
Lordship, serious case, Your Lordship, item number 44. Your Lordship, today I am completed 43 days. Arrested date is 6/6. And the sections are, Your Lordship, 16 close to. This is the 2 years of imprisonment, and 318 close 4 is 7 years imprisonment. 336 close 3 is 7 years, and 340 close 2 is fraudulent death is also 7 years only, Your Lordship. Means 4 sections, there have 2 are bailable and 2 are non-bailable. Those that non-bailable sections, 7 years is imprisonment. So I have completed 43 days in custody. Your Lordship.
You have not
And
completed statutory period.
we are
So I
waiting
have
since-
to,
Total 7.
you have to wait longer. Wait little more till Tuesday.
Monday will be fixed.
Monday again, you will have to wait till 4:30 and you will again submit that Tuesday. See, Tuesday কিমান আছে?
Tuesday.
On Thursday at 2 p.m. Then it will not be left over.
Yes.
Series case on Thursday at 2 p.m. Okay.
Okay, item number 51. This matter was yesterday listed as motion item, Lordship. And my learned friend says that case diary was here, so therefore Lordship was fixed today. So I'm only praying that matter will be fixed on Thursday, Lordship.
Okay, Thursday.
And similar prayer to item number 14. He is in custody, so Thursday, that matter also will be fixed on Thursday.
Thursday.
Item 51 and 40. Lordship. Okay.
One player. Item number.
Item number 48, my lord. Yesterday also it was listed, my lord. So my prayed, my lord, a date may be fixed, my lord, Thursday or Friday, my lord.
No. Unless
48, my
Strike out কৰিব লাগিব এটা নাম।
49 days.
40 হেৰি না?
6th August.
Look, there is no interim order, my lord.
এটা নাম strike out কৰিব লাগিব।
Yesterday also it was listed, my lord. And fixed for today, my lord.
On 29th July. 29th July.
Item 41 may be fixed. I'm just interpreting, that series 42 to 45, along with 49 and 50 also, along with that. 42, 43, 44, 45, 49 and 50 also.
Oh.
is there.
Lordship,
Okay, yes.
The Lordship petitioner number 2 got already arrested. So his petition become infractious. So petitioner number 2 from item number 49.
Can
that
we
will-
get-
No, that may be submitted on that day.
That day.
On that day.
So with the two other-
41 may be fixed on Tuesday, lordship.
What is it?
Get a law. It is there, your lordship.
CD is there.
Yes, your lordship. Item 41.
41.
Yes, severe. 41, hold on.
Okay, Tuesday.
My lord.
Item 46 and 47. Yesterday also it was fixed, my lord, and CD is there. my lord. There's an AB without interim, my lord.
You are on interim.
No, my lord. 46 and 47.
Case diary is there.
Yes, my lord.
Tuesday.
Oh, my lord.
Case there is, my lord. Can it be next week, my lord? Any date, my lord, next week, my lord. I think lordship fixed it on 29, my lord. Can it be?
No, let it be on 29. Because if we fix all cases on a single day, let it be on 29.